Can you start? I kindly request all the participants to mute their mics. A very good morning to everyone. It gives me an immense pleasure to host this IQAC initiative state level virtual seminar on intellectual property rights, that is IPR, organized by the Department of Chemistry, KLS JT College, Gadag. I heartily welcome to you all to this event.
I can't hear actually.
You can't hear, sir? It's the mark of our tradition to invoke the Almighty at the beginning of an event. So let's start this event by a prayer song. I request Vinaya for a prayer song. Over to you, Vinaya.
ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯೆ ಪ್ರದಾಯಕ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ಪಾರ್ವತಿ ತನಯ ಮೂರುತಿ ಶರಣು ಮೂಷಕ ವಾಹನ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯೆ ಪ್ರದಾಯಕ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ನಿಖಿಲ ನೇತ್ರನ ದೇವಿ ಸುತನೆ ನಾಗಭೂಷಣ ಪ್ರಿಯನೇ ನಿಖಿಲ ನೇತ್ರನ ದೇವಿ ಸುತನೆ ನಾಗಭೂಷಣ ಪ್ರಿಯನೇ ಕಟಿತಟಾಂಕಿತ ಕೋಮಲಾಂಗನೆ कर्णकुण्ड तारणे शरणु विद्यानायक शरणु विद्याप्रदायक शरणु सिद्धि विनायक. Thank you, ma'am.
Thank you, Vinaya, for such a heart-touching prayer. Now, I request our HOD, Dr. M.B. Patkar, sir, to make the welcome and plenary speech. Over to you, sir.
Good morning, everyone. Distinguished participants, ladies and gentlemen, and my dear students, I am glad to welcome you all the virtual seminar on intellectual property rights organized by Department of Chemistry, KLE, JT College, Gadag. Firstly, I welcome our resource persons, Dr. Vidyasagar PC, Rani Channamma University, Belagavi, and Dr. Suhas R, JSS College, Mysore, for accepting our invitations. Welcome you, sir. Nextly, I extended my warm welcome to our respected principal, Professor P.G. Patil, sir, for giving us their consent. Welcome you, sir. I also welcome all the faculties of our department. Next, I also welcome all the participants, lecturers, and all the students who have joined us today. Welcome you all. The webinar today highlights general aspects of IPR and overview of patent system in India. Intellectual property protection is critical to fostering innovation. Without the protection of idea, business, and individuals would not reap the full benefits of their invention. Knowing about patent is also very important. Patent is a legal document that is granted to an inventor by the patent office in order to protect the subject matter seeking protection. Our today's webinar also stresses on academic research and copyright issues. Research is an invaluable tool for building on crucial knowledge. When you have a proper in-depth analysis of any topic, the result comes out to be fruitful and also knowledge is enhanced. Research creates development. Most influential purposes of research are exploration, description, and explanation. The knowledge generated by research contributes to benefit and influences society, culture, our environment, and the economy. So I hope virtual seminar will definitely give you opportunity to increase your research skills and enhance your knowledge that can supplement in your field of study. I once again welcome you all on behalf of our Department of Chemistry, KLEJT College, Gadag. Thank you.
Thank you. Thank you.
Madam, Sweta madam,
Yes, sir. Yes, sir. Yes, sir.
oh,
Thank you, sir, for your earnest welcome and plenary address. Now, I request Professor Lakshmi Kiledar ma'am to introduce our resource person for the first technical session.
Good morning to all. It's my immense pleasure to introduce our today's resource person of Technical Session 1, Vidyasagar C. He completed his graduation in BSc from Government First Grade College, Chitradurga, and MSc and PhD degree from Kuyempu University, Karnataka. And initially he joined as a research associate at Indian Institute of Science, Bangalore, and later on he completed his postdoctoral degree from Neurolin, Government of Mexico. He is a visiting faculty at Sangoli Rayana Government First Grade College affiliated to RCU, and also he presently working as a assistant professor Department of Chemistry Rani Charma University, Belgium. Sir has received many awards and honors in his research career. Rajiv Gandhi National Fellowship from UGC New Delhi and received many best research paper articles from elsewhere team, and sir has also got postdoctoral fellowship from Indian Institute of Science from Bangalore and Young Faculty Award from Venus International Foundation, Chennai, India, and ITS and DST Award from Department of Science and Technology, Government of Karnataka, and he is also bagged appreciation certificate for reviewing article elsewhere team, Netherlands. He is editor-in-chief and International Journal of Advanced Material and Technology, India. His present ongoing research interest on synthesis and characterization of semiconducting nanomaterials for energy devices like photovoltaic cells and dye-sanitized solar cells, and also on reduced graphene metal oxides and any other metal oxide composite for energy and environmental remediation. Sir has totally published 33 papers and written 6 book chapters, and his present citation is 521 and H index is 11. He have 3 patents. We wish you all the best for your upcoming research work, sir. With this brief introduction, I will conclude my remarks. Thank you, one and all.
Thank you so much for your brief introduction.
Thank you, sir.
So, shall we start?
yes sir.
Okay, I will share my slides actually. Just particular sir.
Yes sir.
You have to make me host to share my screen.
Okay sir.
No, sir, he's there. He's there, sir. He's telling he has to be host. But ಅವ್ರಿಗೆ ಪಿನ್ ಮಾಡಿದ್ದೀನಲ್ಲ. ಹಾಂ. ವಿಡಿಯೋ ಆಡಿಯೋ ಎರಡು ಆಫ್ ಮಾಡಿ ಸರ್ ಅವ್ರಿಗೆ ಪಿನ್ ಮಾಡಿದ್ದೀವಿ ಸರ್ ಹೋಸ್ಟ್ ಅವ್ರು ಹೆಂಗೆ ಮಾಡ್ತಾರೆ ಸರ್ ಈಗ ನಾವು ಹೋಸ್ಟ್ ಮಾಡಿದ್ವಿ ಲೈಕ್ ಯು ಕ್ಯಾನ್ ಶೇರ್ ಯುವರ್ ಸ್ಕ್ರೀನ್ ಅಂತ ಹೇಳಬೇಕು ಸರ್ ಅಷ್ಟೇ ಅವ್ರಿಗೆ ಪಿನ್ ಮಾಡಿದ್ದೀವಲ್ಲ ಅವ್ರದ್ದು ಸ್ಕ್ರೀನ್ ಕಾಣುತ್ತೆ
ಅವರ ಪ್ರೆಸೆಂಟಿಂಗ್ ಓಕೆ
I think you can see my screen, right?
ಎಸ್ ಸರ್ ಎಸ್
So I hope the slides are visible now.
ಎಸ್ ಸರ್
Okay. We'll start. How much time I have?
1 hour ಸರ್
1 hour. Okay. So good morning to one and all. And first of all, I thank the organizers for giving me an opportunity to share few things, whatever I know related to IPR. Actually, it's a non-scientific talk where it attracts a wide range of audience, I hope. So today's talk is all about IPR. Actually, IPR is nothing but the intellectual property rights, the first term, which includes ideas, trademarks, creation, novelty, brands, licensing, copyrights, protection, everything it includes. This is about how imaginations convert to ideas, in turn ideas to creativity, and the creativity leads to innovation. So for instance, innovation is all about ideas, I told, ideas, intelligence, solutions, inspirations, creativity, visions. So one by one we'll discuss in the next slides. Just look at the two world-class leaders. Both are known for the innovation in their fields, just because of thinking outside the box. Okay. And as Sundar Pichai told, CEO of Google, as a leader, it is important to not just see your own success, but focus on the success of others. So when you think for the societal benefits, if you are going to improve the products and all, then you will become the leader. The same way Steve Jobs we had, he also told innovation distinguishes between a leader and a follower. Only innovative and creative thinkings make them to be a leader. So if you want to see different results, you have to do things differently. The best example is the baby elephant. When you tie the baby elephant with a small rope, it's difficult to escape. It is highly difficult to escape. Okay, as it grows, still it thinks the same instead of trying again. It's all about a belief in the system that's matter. The same way, we stopped thinking outside the box since we have not thought of that when we are child. So the bottom line is how ideas convert to creativity, that matters a lot. Ideas, imagination to ideas, ideas to creativity. So we'll go by the introduction, what is actually intellectual property, how it came from the beginning. If you look into the origin of intellectual property, we will find that intellectual property can be attributed to human creativity itself. Human creativity, as we know from certain Asian cultures, there was no concept of creativity that existed in ancient cultures. It is just the fact that they didn't respect or identify it as a concept. Rather, they found it as a new things. Which is an important thing for us till in the debate also. In fact, creativity was attributed only to divine origin. In fact, at one point in the ancient cultures, art was regarded as a discovery that you make and not something which you create on your own. So art was a discovery, and discovery is not something that was created. So the concept that existed in ancient cultures was the fact that human beings didn't create anything on their own. Rather, they discovered it and converted one form to the another form. We have a laws and laws in thermodynamics also. We cannot create anything, we cannot destroy anything, just it takes from one form to another form. That's what we are doing. For example, if you take a water, it has three phases, right? Ice, water, liquid, and gas, solid, liquid, gases. We cannot create a water molecule and we cannot destroy water molecule also. Just it takes a different phases and a different forms. That's what the things we are doing. So in the next slide, we'll talk about art. What is art and all? So art was regarded as a form of imitation, and imitation, as you already saw, came through the process of discovery. What we discovered that we are imitating, that's it, and doing research. Now this philosophy regarded that God was the creator and all other things created by the God. That means we cannot create anything. God only created everything. So we had the creator and we had the created things also. So if you find a strangle even in modern intellectual property law, where especially when it comes to patent law, there is a lot of difference between discovery and invention. Discoveries are not regarded as inventions because the discoveries do not lead to inventing or coming up with some things, new something which is existed. So this issue that existed between the people in the ancient culture also. So you see that it is the same debate also refers nowadays. Actually, this the what I, about the creativity. So when we look at the creativity, we can look at two broad classes of thinkings. One, we had a religion, which initially told we had the which is initially told us the creativity was the province of God, and then we had the Renaissance where the individual was given more importance towards the discoveries. So we came to an individual centric model where we moved forward and said that it is not just creation that is of a divine origin that matters. Even the creations by the individual itself could be the thing to be considered in future. So if you look at the human-centric intellectual approach, the human-centric intellectual approach itself had imagination at its center. It was regarded that a genius is a person who was imaginative and over a vibrant imagination also. Whereas a talent or something which was below the level of genius, so we could have talent to do ordinary task, but to do extraordinary, we had to be genius. Again, this is something which we will find in modern intellectual property debates. In inventor is somebody who has the spark of a genius, whereas a skilled person or a person is skilled in art is just a talented person. So, how does the patent law decide, or how patent law determines that there is a difference between normal talent and that of a genius person? They merely look at the fact whether a skilled person who is an ordinary person in that field could have come up with the inventions. If the skilled person could not have could not have come up with the invention, then patent law regards that as a work of invention, or rather, the patent law regards that there is an innovative steps which is similar to the contribution of a genius. So human creativity revolved around the human imagination only, and human imagination was something that was attributed to the work of genius, we call. So this was so creativity is this. So creativity came to be equated with domain changing contributions. So we could look at some similar contribution that lead to certain creation of a domain and or changing the knowledge. There were various theories on creativity. Creativity. We have theories of psychology, theories of cognitive science to study the different forms of materials or different forms of theoretical aspects towards any industrialization of materials. So now imagination, it was believed that imagination lead to new ideas. Whatever is there, whatever we imagine it, that leads to the idea, and new ideas came up because of operating in predictable ways, and this predictable way mapped or had a relevance to existing concepts. So in a way, imagination had to do something with what was already there. So all of a knowledge or all of a creativity can be regarded as a building on existing knowledge. So when we look at the creativity from the perspective of intellectual property rights were creative endeavors. And if you look at human creativity itself, human creativity can be attributed to how we build an existing knowledge. Okay, how we make things do differently above the existing knowledge or existing things. So just how creativity comprises of building on existing knowledge. So also intellectual property is the same thing which is built on what is already known. That is called what we call innovation. So now if you look into this slide, creativity as a problem solving. Now creativity also has a bearing on problem solving. Now creativity can is something that overlaps with what we called intelligence. That is what intelligence make it to intellectual. Yeah, came from the intellectual from means that that's why where we get the term intellectual from based on the intelligence. So if you look at this slide, mental process of how it works in the creation of creations and innovations, the mental process when it comes up with an original idea, and the original idea results in an unknown solution to an existing unsolved problems. We say that it results in creativity in solving a problem, but now creativity in solving a problem is again what we call creativity as a problem solving, as it is a relevance to intellectual property rights, because when it comes to an invention, one of the ways in which attribute of invention has a unique, yeah, which is looking at whether it is solved pre-existing problems or unsolved problems. So this is how creativity came to be attributed to originality, or the things being original, or the things being novel. Now, originality is a requirement under the copyright regime. The copyright regime requires copyrighted works to be original and novel, or novelty is something that is relevant to the patent regime. So patent law requires inventions to be novel, and copyright requires works to be original. So copyright and patent are two branches of law under the intellectual property rights that we study in the next slides. So an innovative solution called either result in an innovation or it could result in an invention. Innovation is a broad term, that's it. Intellectual property is more concerned about invention because patents would protect inventions. We do not say that all innovations can be protected. We only say that inventions can be protected by the way of patents, and the inventions are the subject matter of patents law. So when we look at the problem solution approach in or when we look at the creativity as a process of problem solving, you have a problem for which if find the solution, and if the solution is creative, then we call that as an innovation. When there is a problem that is solved using a creative process, that entire process we call it as a process of innovation. So this is the best example for what think about what is the innovation. This is a triangle relationship. If you look at the three circles, this is the innovation is nothing but a triangle relationship between desirability, viability, and feasibility. Desirability means the desirable solution that your customer really needs, what they expect, that you have to think in the society. And the viability is nothing but the profitable solution of industries with a suitable low cost or low more yield methods or different process or methods that they think about the industries. But the feasibility means whatever we create, novelty and the implementation implemented by industries, how it is feasible in the society. Means a feasible solution that how is it different from the current operating capabilities, and how feasible reactions in case of pharmaceuticals or chemistry concern, how feasible reactions or process is in the industry, and how it could help the society more than the existing knowledge or existing techniques. So now we were mentioning that the exclusive set of rights that an intellectual property rights and composers would also vary depending on the kind of intellectual property right. And we were saying that in the previous slides, if it is a copyright, then the copyright gives the creator a fixed number of years to print, to publish, to perform, or to film, or to record a literary, artistic music or other cinematographic works. So the set of exclusive right in copyright pertain to making more copies in a different forms. That's what copyright we call. The set of rights, exclusive rights in a trademark pertain to using a symbol or a word that is legally registered or established by any registered companies, or it's about the products. It could be products or even services also. So in a trademark, the right is for you to describe a symbol or set of words. The best example is Nike symbol, Adidas, the Mercedes-Benz logo, or any of the logo, Coca-Cola, Pepsi. These are all registered trademark patents. In that case, what happens? No one can use that trademarks in their companies actually. So now you could use this right. If you use this right, then they can have a complaint a large against that company also. Now there was a case where I saw, I think in the market also we see that duplicate Puma, duplicate Nike garments, shoes, everything will come in the market. But thing is, they won't bother. The big companies, they won't bother because the small profitable things what they are doing, small companies are selling it. That is nothing to do with the big companies. They won't have a big loss. That's why they won't consider those things seriously. If it is a serious thing, they definitely they will go for the legal actions. So it may not be the business in which you can stop others from using it. You could also stop people from using it. Anybody can claim loss complaint. If the mark is well known, it is a reputed mark in the society. Now look at that. In a patent law, we were talking about rights relating to manufacturers, marketing, sales, and in some cases importation. So the nature of the subject matter, we are trying to define intellectual property right, and we are trying to understand that the subject matter can be different for different rights. Now the registration process is different for different rights. The exclusive set of rights that patents and trademarks and copyright then the geographical indications encompasses, they themselves can be different because of the subject matter being different. The duration can be different. Trademarks can be or of a fixed term, but they can be renewed as long as the right holder places some of the trademarks that are in operation, like a Coca-Cola, Pepsi, Puma, Nike, everything. But Coca-Cola has its 100 years of services in the world. So some of the trademarks can be in that situations where if the right is not renewed or if the right is not used, then that mark cannot be enforced anywhere else. So if you look at a business that is survived for 100 years or since from the many years, and you could actually see that the marks are being kept alive. So the best example is Coca-Cola. For since 100 years they are keeping the trademark alive only, and in future also no one can do that, still it will be alive. So in that because they pay official charges every year and they make it keeping alive in the society, so no one can use that. So and you will find that it can be the trademarks in business parlance. We say these are kind of unlimited life intellectual property. There is no limit to the category of intellectual property because their lifetime life is as long as the right holder wants to keep them alive, just he has to pay the money to the government as official fees, and also need to take action if the people are misusing those symbols. So there are two things the right holder need to pay the official charges to keep his symbol or company trademark as alive for lifetime, and they have to take the action if somebody is using the logo or words without his consent. Otherwise, it could be assumed that he has given up his rights. The best example is the Coca-Cola has design on its bottle also. Coca-Cola has copyright protection in the way in which its products are displayed it in an artistic work, and the way Coca-Cola has trademark on the world. The trademark without doubt is an unlimited life intellectual property. It's unlimited. There is no limit to it. The other rights came and go in. Sorry. Okay, somebody is speaking. I think. Okay, doesn't matter. So the many companies may come and go if they had assumed that they had registered as a design patent and was a limited life for it. That may come and go, but the mark can only be used by the right holder. So it's a combination of multiple rights also it may be. Then the trade secrets, they are a category of an intellectual property which fall within the unlimited life intellectual property. They are not limited by if you can keep the trade secrets confidential, then you can enforce it. So the most important thing is geographical indications. This geographical indications is a sign used on products that have a specific geographical origin and the possess quality or reputation that are due to that original origin. The best example is Darjeeling tea, Banaras sari, Basmati rice, and even Belgaum Kunda, Goka Karadantu, Tarwad Peda, Mysore Agarbatti, Tirupati Laddu. These are all what comes under geographical indications. They also will be having a patent, so no one could use in somewhere else in Bangalore. They cannot use Bangalore Kunda. It should be sell it as Belgaum Kunda only if they are doing it. So when goods come from a particular place and that quality of goods are attributed to that particular place, that we call it as a geographical indication. Then that product can be regarded as a subject matter of a geographical indication, and that can be registered every year. So moreover, This is not limited to agricultural products. It extends to other products also like wine, spirits, handicrafts, and so many etc. So why we need these geographical indications? Everybody asks somewhere. It is to protect the knowledge. That's it. We require geographical indications for the protection of knowledge and community rights so that there can be a fair competition. Otherwise, many companies will make it a duplicate and spoil the existing company name also. So when it comes to this duration of patents, duration is true for all the countries, and it may change country to country also somewhere. The entire lot of intellectual property into two categories. One is from the business perspective. If you have the limited life intellectual property, where the duration is limited, after which it falls into the public domain and people can use it, and you have the unlimited life intellectual property where subject to renewal, it can be alive forever by paying the official charges to the government every year. So today across the globe the duration of patent is 20 years from the date of application, and now we have this uniform system because of the TRIPS agreement. TRIPS is nothing but the trade agreement related intellectual properties. Okay, trade related aspects, intellectual properties we call. So in this TRIPS, which is agreement under the World Trade Organization, WTO we call, so that the TRIPS agreement is the agreement which covers intellectual property rights, and every WTO member is bound to implement that agreement because it was an international agreement, and most of the countries who are all members of this WTO have across the board 20-year term for making any for grant of any patent. So in India, the duration of patent was 14 years earlier, but they made it to 20 years now. Except for pharmaceuticals, in India the term used to be to 7 years. It was a flexible term. If it used to be different for pharmaceutical foods and agriculture products, the term used to be even lesser now. Now you may ask why 20 years? It is to so many years, so many generations we have to pass it and all. So I mean, where did we get the 20 years from? I mean, there should be some logic behind 20 because we know that 20 years is not only true or not only applicable for all the countries. It is different for different countries. It is applicable for a certain technology agnostic, okay, related to technology, where technology is now protectable in by virtue of its TRIPS agreement also. But the lifespan of the technology is very short, with maximum 3 years. So what we can do is by the time the patent grant completes its year 20 years, the new technology will come up in the society. The whatever the patent was there for technology, that will become old technology. That's why their TRIPS agreement are trying to reduce the duration of the patent for the technology aspects and pharmaceutical also, that because that has to come to the society as early as possible for the benefits of the people. So patents term, as we understand it today, internationally is not technology specific, whether it is a pharmaceuticals, aeronautics, biotechnology, software. And one more thing, only 4 countries which grant patents on software. So it's a 20-year period, and we know that a 20-year period doesn't make sense for all the technologies. Hopefully, in future, TRIPS will make it lesser the patent period. Some technologies are so quick that has to come to the market so easy, and the pharmaceutical the best example is COVID-19. It didn't go under for patent only because we need it as early as possible for the to save our earth. That's why they didn't allow for the patent for 20 years or 7 years. Those kind of decision will be taken from the TRIPS agreement only. So the patent is nothing but here is the best example for what and all you can do. The robot, the functionality of the robot you can see here that can be patented because no one can do that the same robot Okay, then the design, the material which is used, the shape of the robot, and with the circuits they use, everything that comes under design patents that you can patent. And trademark is anyhow we know the company name, no one can copy the Honda, then Bajaj, anything else. No one can keep that one. And the most important is copywriting, taking copyrights for the coding of the robot. That is very important. No one can use the same code for the fabric manufacture of robots. In the same way, we have so many trademarks, have patents. Google, have Amazon, Flipkart, these are all the trademark comes under trademarks. So when it comes to patents, a patent is a form of intellectual property that gives its owner the legal right to protect their inventions. When we get a patent, they have exclusive right to protect from others to making, selling, or importing the goods. There are generally three types of patents: utility patent, second one is the design patent, third one is plant patent. Actually, plant patent is not in India; it is a US based patent. The term of utility patent and plant patent is for 20 years, whereas design patent is for 15 years. Now, coming to the utility patent, these are simple inventions which are novel and innovative. This could be the product or a process or a method, anything else. So, design patent is a type of registration which is given to the appearance of the product, physical appearance of the product, not related to any functional aspects of the product. This term is for 10 years and it can be extended for 15 years also. And the third one is a plant patent, as I told just now. This concept is in US concept only. There we can get a patent for sexually produced plants. But in India, nothing like a patent, where we have protection of plants under the Farmer Right Act from the government, in which we can protect the newly crossbreeded plants in their field only. So everything is nothing but what can be protected or what can be patented. Patent can be process or methods, whatever may be. The process which is new and it has a lesser number of steps compared to the existing knowledge or existing process. It should be low cost or better yield or good performance towards any applications or towards any industrialization of materials for certain properties. Similarly, a composition also which should be new. The composition can be a combination of the products or a single active ingredients with other components, or simply it could be alloys or a mixture of compounds. Anything else, if you mix the single component to other component also, yeah, it gives another component. Means A plus B gives C plus D in the mathematics okay? Like that. The combination can change the entire properties that can be patented. Then the research, if you go for the research, means it takes a lot of time to speak. Okay, but the research is an important aspect. So we can file patent for process methods, then synthetic procedures, then any particular applications if you find in the laboratory which can be industrialized like that we can may have a patent. So the next is criteria for patentability. What is the criteria? So criteria is very simple: novelty. It should be novel. It should be new, not published anywhere else. So yeah, next is innovative steps. It should have technical specifications or technical advantages, or it should be economic significance or profitable towards the societal benefits. Then the industrial application. It should have some use or applications or solutions for problems. Actually, it should reduce the steps, or it may take a lesser components to make it. Anything else, okay, that we can make it in the laboratory or in the industry also. So the main thing is what cannot be patented. We know that section 3 and 4 is there in the Indian patent. They have mentioned clearly that what cannot be patented. So first one is the scientific discovery. Scientific discovery means If you discover any new element I talk about in the form of science
It's
related
not
things,
working.
any element or that cannot be patented because that new element whatever you discover that has to be exposed to the public so that more number of studies can happen on that same area. The best example is the ISRO and the NASA. If the ISRO and NASA discover a new planet now in the future, that cannot be patented by the country because the new planet should be under study for a longer term, and that's what we cannot patent those kind of scientific discoveries. That's why discoveries cannot patent. In the science we have some laws, thermodynamic laws we can call, or so many concepts are there, theories are that cannot be patented because we study it in our in the syllabus. That's why scientific discoveries cannot be patented so that we can study thoroughly in future about the same material. So living things, living beings, plants, human beings, animals, microorganisms, all living things you cannot patent. You cannot, otherwise we can have a patent on our wife also. So on living things we cannot have a patent. New form of noun substance means already we have some substances in the industry or some laboratory or anywhere else. So just changing some of the things we cannot have a patent. It should be new material, new molecule, or in the pharmaceutical industry they make it a new molecule. Just if you synthesis a derivative of that molecule means it cannot be patented. Then traditional knowledge, so it comes under the geographical this one geographical area also. In this every traditional knowledge different for different geographical region. So we have some dressing code or folk dances or folk songs also that cannot be patented because that's our tradition. Otherwise we can have so many patents. Even doing puja also we cannot have patent. Those are called traditional knowledge. The what we have in our religion, in all religions. And the business methods we cannot patent.
Principles are just
Business methods means the online booking tickets, online buyings, products, or maybe online transaction. All those things you cannot have patent because that is a very important aspect for the society. That's why you cannot have patent. And the mathematical methods, you may have discovered a new formula, but to discover or to get that new equation, you will be doing so many steps. In those steps, we may include integration, we may have partial differentiation, or we may assume some constants, the existing constants like Planck's constant, and all those constants we can assume. Those are things we cannot have patent on mathematical methods. We cannot have patent on mathematical steps. And renewable sources, as we know, air, fire, water, and all, we cannot have patents on renewable sources. And the administrative protocol, whatever the administrative protocol is there, governance, e-governance, and all, that we cannot have patent to filing it, to complaint. So many things are there in administrative protocols. Though those things we cannot have patent. So, procedure of getting a patent in India. Patent Act was formed in 1970s. The basic requirements are the area, nature of the invention you have to mention, similar existing solution and how it is better from the existing products. You have to brief it. Then a brief about how does it works, the entire working principle and explanation you have to write it up. Then description of invention, what exactly you want to have patent in the process, that you have to mention clearly. Then advantages of your invention over existing solutions, how it is better than the existing solutions or how it is better than others, from where your patent will fit into the application, that you have to mention properly. And the most important documents, we have form 1, form 2, form 3, form 4, proof of rights. That means you have to make some videos or some results you have to submit it as in the write up or it may in the form of video. And patent specifications. In what we are, what exactly you are having the patent, that specification you have to tell, exact composition, what is the method, what is the time, everything you have to mention in the form. Then statement of and undertaking, that you have to statement declare that no one did till now like that. You have to, they have some formats that you have to fill it. Then declaration as a inventorship, that means the it comes in the royalty in case if it is a pet, if you have a patent, royalty for and sharing that, and everything you have to describe. And other normal basic documents you have to attach whatever they ask, that you have to write it. And when you have patent, we have in patent also two types. So one is provisional and complete. In provisional patent, what happens? So usually, provisional patent is filed when the applicant feels that this can it has a discovery or new idea. It has reached that stage that I have to disclose in the form of writing only. Only in the form of writing report only you have to have patent. That's why in the process of filing it, no one can see that write-ups. So that's why beginning only you can have a patent for the I'm going to write up these things. I have new ideas, so you can have a provisional patent, but they won't give the file number in that. So later onwards, you have to submit the specifications to the patent office, and it helps to preserve the priority date of the application. But anyhow, after you have to submit only after receiving the provisional specifications and the forms, all the four forms, everything, they will give the application number. By till then, they will that concept and that write-up will be preserved like that. The complete specification is nothing but it is very important document in a patent application to the grant of patent. Means the application must submit it within 12 months from the date of filing the provisional applications. That means you have to submit the proofs, whatever may be in the form of videos, photos, or in the form of results. They have to submit it after the provisional application. In this application, applicant gives a complete description of his invention, whatever he did till now, in the form of proofs. The submission of complete specification period can be extended by a maximum period of 6 months. That's it. So later onwards, anyhow, you have to submit all the forms. Okay, you have to mail it. So we have 4 patent offices in India. Patent office in Mumbai we have, in New Delhi we have, and Chennai we have, and in Calcutta they have some judiciary states. Mumbai, Maharashtra, Gujarat, MP, Goa, Chhattisgarh, and Union Territories are welcome. And if from Karnataka, if anyone wants to have patent, means they have to apply to the branch, Chennai branch. There all south states will come: AP, Karnataka, Kerala, Tamil Nadu, and Union Territory of Pondicherry and Lakshadweep, including Telangana also will come, and the rest of the states will come under Kolkata. So this is the just a bar chart. So that means till 2020, how many patents they have given. State-wise, I have mentioned. Maharashtra is on top, almost reaching 10,000 patents, 9,207 as per 2020, and the least is Punjab. That's why what we have to, because Maharashtra has so many industries and industrial area they have. That's not, maybe for that sake they have more patents. So the main significance of this patent, copyright, trademark is all about how it helps to GDP, the correlation between IPRs and GDP of the country. So that means the good protection and enforcement. Enforcement means we making it action, means industrialization of intellectual property rights are key to promoting international technology transfer, which is important for economic growth, especially in developing economies. Means IPR regime is likely to affect growth indirectly by encouraging the innovative activities that in turn is the source of total factor productivity improvements. This IPR regime could also affect the inflows of foreign direct investment, technology transfer, and trade that might impinge on growth also. They have some quantitative studies also shown that universally imposed minimum standards for patent protection are not likely to contribute to increase the growth in countries below certain threshold in terms of level of development. So all the patents cannot be granted. Only after the scrutiny only it can be. After the scrutiny of applications and the results, it can be granted. After granted, you have to take the license from the government to license to manufacture or to start the production or to start the startup things and all without the and we have to fill some fees, I think government fees and all, so that can be grant. After taking the license we can have industrializing that concept. As a result of this relationship between GDP and IPR protection, developing countries with low GDP per capita tend to receive less technology from abroad. In terms of FDI, foreign direct investment, likely due to poor enforcement because of industrializing the material means we have to purchase it. That's it. The positive relationship between the amount of royalty paid to the world and IPR index also matters a lot. The best example is China. Has shown to be far above the trend line in the world, means indicating that although China has a lower GDP per capita and a lower IPR enforcement, it is still has significant player in purchasing technology from the world. It purchases that means China purchases the patents and they make in China. That's what our government is now doing it now. Make in India. That's what we have to purchase the technology from the abroad. Then we have to make in our own country. That's what China succeeded everything. All the companies manufacturing products are in China because they have a I think they have a very good low labor cost and more resource things and all there in the country. I think so. In future we can also do it. Therefore, economic policies aimed at improving the quality of IPR actions is like to promoting technology transfer and development of the individual countries actually. And in conclusion of my talk, I can only tell that these patents can act as a catalyst in between the academic and means the institutes and the industry. If you have a patents which can be industrialized, then the industry will buy it so that you can get a royalty and they will pay every year for you. The same that's what the patents have a major role in the industrialization and indirect and direct it is depending upon the GDP of our country also. So with this, I will conclude my talk.
ಸರಿ ಜಾಯಿನ್ ಮಾಡಿ
Thank you so much. If you have any questions, you can ask. So we can have few minutes of discussion also.
Yes,
If
sir.
anyone, yeah.
Questions?
Hopefully we get one or two questions, I think.
ಕೇಳ ನಾನು ಲೈಕ್ ನನ್ನ ಕ್ವೆಶನ್ ಏನಂದರೆ ಈಗ ನಾವು ಪೇಟೆಂಟ್ ತೊಗೊಂಡಿರ್ತಾರೊಬ್ರು ಯಾರು ಸೇಮ್ ಪೇಟೆಂಟೇ ನಾನು ತೊಗೊಳಕ್ಕಿತ್ತು
Hello.
ಕೇಳ್ಬೋದಾ?
Sir, one simple question.
Yeah, tell me.
How we improve our problem solving capacity by using our simple existing resources, sir?
That's what it depends upon the creativity, and you should know how it works in the society and how it is beneficial for the society right now. If it is means you can if you are problem so if you have a problem solving ideas, then you have to implement in somebody's lab or you have to have collaboration with the industry and you have to check it out whether it is working and whether we are getting the better performance than the existing one existing methods that you have to check it. So it is nothing to do with the hard work. It is just a smart work we have to do. It means we have to reduce the things, right? And we have to get a more yield. That's what we have to collaborate with the labs or industries. Then whatever your ideas, just to go and discuss and implement there. So they will help you whether it works or not, and how it can be helpful for the industry and society. Those because industry people will only know what is the exact problem in the society. So if you have contacts with the industries and some other in the institutes, you can discuss so that it can be implemented or check it out for industrialization or for patent process.
Okay, sir. Thank you.
Okay, thank you.
Sir, I have a question.
Yeah, tell me.
So, like, if someone has taken one patent already, and even I have the same ideas of that, so again, can I take that patent or what?
No, in that case, for example, think that you have Indian patent,
Yes, sir.
and somebody wants to do that same
Yeah.
thing, same thing. Means same thing they cannot do, but literally they can change little
Change.
bit. They will change the property or something, material process and all. But they cannot have the Indian patent because already you have Indian patent here. So they can go for the other countries' patent, like China patent, Japan patent, US patent, Indian patent, and all. Even though they will search for that one, but it depends upon the review process, how they will accept or how they. Sometimes it may be rejected, or sometimes it may be accepted because all the filed patents will be undergoing for review process, critical review process. So that depends on them whether we can grant or we can have published this patent in our country. That can be because in India means no one can do in India only if you have Indian patent.
Okay.
So other countries they can make it have all the global patent, then no one can do anywhere. If he is living in underwater also he cannot do.
Okay, sir. Okay. Like,
Okay.
is there any criteria, sir? Like, how much percent there should be a difference from that patent from ours?
Maybe around we cannot exactly tell what is the percentage difference. Only thing is if you have for example in industry, for example I will take the robot only
Okay, sir.
because everybody is from arts science department. If you have a robot, as it happens, it will cook. Okay, now for cooking also robot is there.
Yes.
Okay, for our service also robot is there.
Yes.
If you prepare a robot for driving, that can be patented.
Okay.
Driving means it should have some different applications.
Different applications.
If you have a housekeeping as a robot, that can be patented. Okay, and that depends how it is different, how it is helpful. That everything.
Okay, sir. Thank you, sir.
Thank you. Thank you.
Hello? Hello, sir.
Hello.
Hello? Hello, sir. I have a question, sir. Hello?
Yeah, ask me.
Yes, sir. What is the best way to protect a literate work posted on online for a teacher to study or student to study? Sir. Hello?
These I think you're talking about teaching materials, right? Uploading in
It means,
that those things, as I told, the concept of teaching and all we cannot help it. So, but it is if you use a scientific teaching board, smart board, for example, smart board, that can be patented, smart board. But we cannot have patent for these teaching materials and all, because if you have a novel concept that can be patented, but whatever the existing subject is there, and your teaching style may be different from others, but that cannot be patented.
okay. Okay. Okay, sir. Thank you.
Thank you. Thank you.
Excuse me, sir. I have one question.
Yes, yes, ma'am.
Sir, is there any program in university to create an interest to our students?
In what sense?
Like any diploma course or any certificate course like that?
That right now we don't have those certificate course or diploma course on intellectual property rights, because we can start it, but the thing is we have to look at the incoming students also. But we can arrange the workshops on the intellectual property and all. That is enough for 7 days or 10 days workshops and all. We cannot have a diploma in intellectual property. That is a selective basis, na? So everybody cannot
To create awareness, no, sir, for
awareness. To create awareness, we can have a workshop like this, conferences, and that we can do it.
yes, sir, thank you.
Any other questions, please?
So if there are no questions, then we can conclude the session. Participants are free to ask the questions. No questions? Then let's conclude the session.
Thank you so much.
I thank our resource person, Dr. Vidyasagar CC, to present his talk on the topic General Aspects of IPR. Thank you so much, sir, for sharing your fountainhead of knowledge regarding the intellectual property rights, human creativity, kinds of IPRs, duration of patent, and criteria for patentability. Thank you once again so much, sir. Thank you, sir.
Thank you so much for giving me opportunity so that everybody can get the knowledge on IPR now.
Thank you, sir. It
Thank
was
you.
very
Thank you,
beneficial.
Monica.
Thank you, sir. Now, I request Dr. Kumar HK, sir, to present the introduction of a resource person for the technical session 2. Over to you, sir.
Good morning to one and all. It is an immense pleasure to introduce the resource person of the technical session 2, Dr. Suhas sir. He obtained bachelor, master and PhD degree from University of Mysore. His topic of interest is peptide and medicinal chemistry, conjugation chemistry and dendrimer synthesis. He has more than 3 years of postdoctoral research experience from the University of KwaZulu-Natal, Durban, South Africa, and presently he is working as Assistant Professor of Chemistry at JSS College, Uti Road, Mysore. In total, he has 14 years of teaching and research experience. He has published nearly 55 research articles, including reviews, invited books, chapters, and proceedings in highly reputed journal with good impact. He has bagged several roles. To name a few: Junior Research Fellowship Award by LTMT, Mumbai, India; Best Paper Award by VGST; Outstanding Research Article for Postcard Publication; then prestigious NRF DST Postdoctoral Scholarship, South Africa; full sponsorship for UK Indian Workshop, among many others. Further, Dr. Suhas has organized and participated in several state, national and international seminars, conferences, workshops at several capacities and bagged many prizes. His papers have been presented in USA, Germany, Australia, South Africa and India. Then Dr. Suhas has organized many academic programs in various capacities as a coordinator, convener, then organizing secretary, member, etc. and bagged appreciation. He is actively involved in administration aspects of the college like governing body, then academic council, NAC and CBCS. With this brief introduction, I will conclude my remarks. Thank you one and all.
Thank you, sir, for introducing our resource person. Now let's resume to our second technical session. I request our resource person, Dr. Suhas R, to present his talk on the topic Academic Research and Copyright Issue. Over to you, Suhas, sir. So, like you have muted, sir. Unmute yourself.
Can you all see my screen?
Yes, sir. Yeah.
All right. Thank you very much for the organizing secretary and the team, especially Dr. Kumar, for your kind words. It is an honor for me to be with a very prestigious institution in Karnataka, that is KLS Notaria Society of College. And I'm very happy to be a part of this webinar. The first session was all about the patenting system in India and a brief overview on IPR. So the second technical session is all about the academic research and copyright issues. So before I move to this, I would like to organizers to know about, do we have only academics or even the students in the seminar?
Yes, the students are there, sir.
Okay, we have both students as well as teaching faculty.
Yes, sir.
Can I go for bilingual, English and Kannada, or only English you want?
Yes, sir. You can go for bilingual, sir.
Because if there are students, I think it's better if I use the bilingual.
Yes, sir.
Is that okay?
Yes, sir. It's okay, sir.
All right. Thank you very much. Ellarigu namaskara. And my topic of today's interest is academic research and copyright issues. So here we have got two major issues. The first one is the academic research. The second one is the copyright issues. ನಮ್ಮ ವಿದ್ಯಾರ್ಥಿ ಜೀವನದಲ್ಲಿ ರಿಸರ್ಚ್ ಅಂದ್ರೆ ನಾವು ತುಂಬಾ ಏನೋ ಅಂತ ಕನಸು ಕಾಣ್ತಾ ಇರ್ತೀವಿ. ಕೆಲವೊಬ್ಬರಿಗೆ ರಿಸರ್ಚ್ ಅಂದ್ರೆ ಗೊತ್ತಿರತ್ತೆ, ಕೆಲವೊಬ್ಬರಿಗೆ ರಿಸರ್ಚ್ ಅಂದ್ರೆ ಇನ್ನೂ ಗೊತ್ತಿರಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಇನ್ನು ಸ್ಟೂಡೆಂಟ್ ಏಜ್, ಅದು ಹುಡುಗ ಬುದ್ಧಿ ಇರತ್ತೆ, ಆಟ ಆಡ್ಕೊಂಡಿರ್ತೀವಿ ನಾವು. ಬಟ್ ವೆನ್ ಇಟ್ ಕಮ್ಸ್ ಟು ಅಕಾಡೆಮಿಕ್ ರಿಸರ್ಚ್, usually people, if they start, especially the student community, they start developing the interest when they enter into second year MSc or maybe in some colleges final year BSc, because they will have some project works. So research, it is mainly of various categories, but here we are mainly concerned with the academic research. Andre enu namma ಕೆಲಸ ಮಾಡೋ ಕಡೆ ಅಕಾಡೆಮಿಕ್ಸ್ ಜೊತೆಗೆ ರಿಸರ್ಚ್ ಕೂಡ ತೊಡಗಿಸ್ಕೋಬೇಕು ಅಂತ ಯೂನಿವರ್ಸಿಟಿ ಗ್ರಾಂಟ್ಸ್ ಕಮಿಷನ್ ಅಂದ್ರೆ UGC ಹೇಳಿರೋದ್ರಿಂದ ನಾವು ನಮ್ಮ ಪಾಠ ಪ್ರವಚನಗಳ ಜೊತೆಗೆ ಟೀಚಿಂಗ್ ಲರ್ನಿಂಗ್ ಜೊತೆಗೆ ರಿಸರ್ಚ್ ಈಸ್ ಒನ್ ಆಫ್ ದ ಮೇನ್ ಕಾಂಪೊನೆಂಟ್ಸ್ ಆಫ್ UGC, that is teaching learning. That's why you will have seen the UGC has established several teaching learning centers wherein they not only teach and they also learn through research. So now what is academic research? First of all, you should understand what is academics. Academics ಅಂತಂದ್ರೆ ನಮ್ಮ ಪಾಠ ಪ್ರವಚನ, ಕಾಲೇಜ್, ನೆಕ್ಸ್ಟ್ ಯೂನಿವರ್ಸಿಟಿ, ಅದೆಲ್ಲ ನಮ್ಗೆ ಅಕಾಡೆಮಿಕ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ರೈಟ್? ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಅಂತಂದ್ರೆ ಇದೆಲ್ಲ ನಡ್ಸ್ಕೊಂಡು ಹೋಗೋದಕ್ಕೆ ಸಹಾಯ ಮಾಡತಕ್ಕಂತ ಆಫೀಸ್ ನ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಆಫೀಸ್ ಅಂತೀವಿ. ಬಟ್ ನಮ್ಮ ಟೀಚಿಂಗ್ ಲರ್ನಿಂಗ್ ರಿಸರ್ಚ್ ಇರೋದನ್ನ ಅಕಾಡೆಮಿಕ್ಸ್ ಅಂತ ಕರಿತೀವಿ. ನೆಕ್ಸ್ಟ್, ವಾಟ್ ಈಸ್ ರಿಸರ್ಚ್? This research, it is a combination of two words. One is re, another one is search. Re ಅಂತಂದ್ರೆ ಏನು? Again, ಪುನಃ, ಮತ್ತೆ ಸರ್ಚ್. ಒಂದ್ಸರಿ ಹುಡುಕಿದ್ಯಾ, ಇನ್ನೂ ಒಂದ್ಸರಿ ಹುಡುಕು, ನಿನಗೇನಾದ್ರು ಬೇರೆ ಸಿಗಬಹುದು ಅಂದ್ರೆ ಏನರ್ಥ ಹುಡುಗ್ರ? And of course, I'm going for basics of basics because I was told that there are students also in the webinar. So even they have to understand this little bit, because this should form a foundation for them, and this webinar should create a platform for them to develop interest for taking up the research in their career. Fine. Research. Search ಅಂತಂದ್ರೇನು? ಹುಡುಕುವುದು. ರಿಸರ್ಚ್ ಅಂತಂದ್ರೇನು? ಪುನಃ ಹುಡುಕುವುದು. ಪುನಃ ಮತ್ತೆ ಹುಡುಕುವುದನ್ನೇ ನಾವು ರಿಸರ್ಚ್ ಅಂತ ಕರಿತೀವಿ. ಅಂದ್ರೆ ಏನರ್ಥವ ರಿಸರ್ಚ್ ಅಂತಂದ್ರೆ? ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ಟು ಫೈಂಡ್ ಔಟ್ ಸಮಥಿಂಗ್ ನ್ಯೂ ವಿಚ್ ಇಸ್ ನಾಟ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಆನ್ ದ ಅರ್ತ್. ಪ್ರಪಂಚದಲ್ಲಿ ಇಲ್ಲದೆ ಇರೋದು, ಭೂಮಿ ಮೇಲೆ ಇಲ್ಲದೆ ಇರೋದು ಹುಡುಕಿದ್ರೆ ಮಾತ್ರ ರಿಸರ್ಚ್ ಆಗಲ್ಲ. ನಾವು ಏನಾದ್ರೂ ಒಂದಿರತ್ತೆ, ಅದಕ್ಕೆ ಇನ್ನು ಸ್ವಲ್ಪ ಏನಾದ್ರೂ ನಾವು ಬೇರೆ ತರದಲ್ಲಿ ಮಾಡಬಹುದಾದ್ರೆ, ಸೇ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಈಗ ನಮ್ಗೆ ಒಂದು BMW ಕಾರ್ ಇದೆ. BMW ಕಾರ್ಗೆ ಅದರದ್ದೇ ಆದ ಓನ್ ಡಿಸೈನ್ ಇರತ್ತೆ, ಒಂದು ಲೈಟಿಂಗ್ ಇಂದ ಹಿಡಿದು ಯೂನಿಕ್ ಆಗಿರತ್ತೆ ಅದು, ರೈಟ್? ನೀನ್ ಇವಾಗ BMW ಕಾರ್ ಮೇಲೆ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಯಾರಾದ್ರೂ ಇಂಜಿನಿಯರಿಂಗ್ ಫ್ಯಾಕಲ್ಟಿ, ಮೆಕ್ಯಾನಿಕಲ್ ಅವ್ರು ಇದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ, ನೀನು ಒಂದ್ ಚೂರು ಡಿಸೈನ್ ಅನ್ನ ಚೇಂಜ್ ಮಾಡಿದ್ರು ಇಟ್ ಬಿಕಮ್ಸ್ ಎ ರಿಸರ್ಚ್. ಅಂದ್ರೆ ನೀನು ಎಂಜಿನ್ ಎಫಿಷಿಯನ್ಸಿ ಇನ್ಕ್ರೀಸ್ ಮಾಡಿದ್ರೆ ಅಗೈನ್ ದಟ್ ಬಿಕಮ್ಸ್ ಅ ರಿಸರ್ಚ್. ಇವಾಗ ನಿನ್ನ BMW ಕಾರು ನಿನಗೆ ಒಂದು 15-20 ಕಿಲೋಮೀಟರ್ ಕೊಡ್ತಾ ಇದೆ ಪರ್ ಲೀಟರ್ ಪೆಟ್ರೋಲ್ಗೆ ಅಂತ ಅನ್ಕೊಂಡ್ರೆ, say for example, if you enhance the efficiency of the engine by another 5 kilometers, then it becomes a research, because in order to enhance that 5 kilometers you will have done lot of work, you will have done lot of researches. Simply you cannot just increase from 15 to 20 or 20 to 25. It is not possible at all. That means you have to work a lot behind that. That is what is known as research, right? And the second issue is the copyright. What is this copyright? ಏನೋ ಒಂದು ಪದ ಹೊಸದಾಗಿ ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ ನಮ್ಗೆ, ಹೊಸದಾಗಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ ನಮ್ಗೆ ಅಂತ ನೀವು ಅನ್ಕೊಂಡಿರಬಹುದು. ಕಾಪಿರೈಟ್ ಅಂತಂದ್ರೆ ಏನು? ಇಟ್ ಈಸ್ ಮೇನ್ಲಿ ದ ಪ್ರೊಟೆಕ್ಷನ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಕಾಪಿರೈಟ್. ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ನೀವು ಮನೆಯಲ್ಲೆಲ್ಲ ಕೇಳಿರಬಹುದು, ಯಾವ್ದೋ ಒಂದು ಆಸ್ತಿ ತಗೊಂಡೆ, ನಾನು ಯಾವ್ದೋ ಒಂದು ಲ್ಯಾಂಡ್ ತಗೊಂಡೆ, ಒಂದ್ ಸೈಟ್ ತಗೊಂಡೆ, ಒಂದ್ ಮನೆ ತಗೊಂಡೆ ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? ಫಸ್ಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ವಾಟ್ ಯು ಶುಡ್ ಡು, you will go to the registrar office and you will get the property registered to your name, right? That is what is copyright. ಅಂದ್ರೆ ಏನರ್ಥ? ನೀ ಯಾವ್ದಾದ್ರು ಒಂದು ಹುಡುಕಿರ್ತ ನಿನ್ನ ರಿಸರ್ಚ್ ಅಲ್ಲಿ ಏನೋ ಒಂದು ಹುಡುಕಿದ್ಯಾ, ಅದು ಇದುವರೆಗೂ ಎಲ್ಲೂ ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ. ಅದು ಆ ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲದೆ ಇರೋದು ನಿನಗೇನಾದ್ರೂ ಅದರಿಂದ ಪ್ರಾಫಿಟ್ ಬರುತ್ತೆ ಅಂತ ಅನ್ಸಿದ್ರೆ then you have to go for protection of your work. That is known as obtaining the license. ನೀನ್ ಇವಾಗ 18 ವರ್ಷ ಆಯ್ತು, ನಿನಗೆ 18 ವರ್ಷ ಆದ ತಕ್ಷಣ ಗಾಡಿ ತಗೊಂಡು ಓಡಾಡ್ಬೇಕು ಅನ್ನೋ ಮನಸ್ಥಿತಿಯಲ್ಲಿ ಇರ್ತೀವಿ ನಾವು. ಎಸ್, ಗಾಡಿ ತಗೊಂಡು ಓಡಾಡ್ಬೇಕು, ದಟ್ ಈಸ್ ಫೈನ್, ಗಾಡಿನೂ ತಗೊಂಡ್ಬಿಟ್ಟಿದೀವಿ. ಬಟ್ ಕ್ಯಾನ್ ಯು ಗೋ ಲೀಗಲಿ ಆನ್ ದ ರೋಡ್ ವಿತ್ ಯೋರ್ ವೆಹಿಕಲ್? ಇಟ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್, ಬಿಕಾಸ್ even if you are 18 plus, without having license, if you take the vehicle onto the road, you will be caught by the police. ಬಿಕಾಸ್ ಲೈಸೆನ್ಸ್ ತೆಗಿರಿ ಅಂತ ಕರೀತಾರೆ. ಏನಕ್ಕೆ ಲೈಸೆನ್ಸ್ ಅನ್ನೋದು ಬೇಕು? ದಟ್ ಮೀನ್ಸ್ ಇಟ್ ಇಸ್ ದ ರಿಟರ್ನ್ ಅಗ್ರಿಮೆಂಟ್. ಆ ಲೈಸೆನ್ಸ್ ಅನ್ನೋದ್ರಲ್ಲಿ ಬೇಕಾದ್ರೆ ತೆಗೆದು ನೋಡಿ, ನಿಮ್ಮ ಹೆಸರು ಅಡ್ರೆಸ್ ಎಲ್ಲ ಬರೆದುಬಿಟ್ಟು, ಹೌದು ನಾವು ಇವನಿಗೆ ಟೆಸ್ಟ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಲ್ಲ ಕಂಡಕ್ಟ್ ಮಾಡಿದೀವಿ, ಇವನ ಹತ್ರ ಒಂದು ಡೆಮೋನು ತಗೊಂಡಿದೀವಿ, ಹಿ ಇಸ್ ಎಲಿಜಿಬಲ್ ಟು ರೈಡ್ ದ ವೆಹಿಕಲ್ ಅನ್ನೋ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ. ದಟ್ ಈಸ್ ವಾಟ್ ಈಸ್ ನೋನ್ ಆಸ್ copyright. ಅದೇ ತರ ಈ ರಿಸರ್ಚ್ ಅಲ್ಲಿ, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, the latest what is happening in the current situation in the pandemic is people have discovered vaccination for the coronavirus, right? Once they have discovered this vaccination, immediately what the thing they do, they go for patenting it one. So when you patent that one, what happens? Your work is protected. When the work is protected, you will see that you are going to earn money from that protection. If you feel that your work deserves the income, if you think that your work deserves the obtaining the capital, so that is known as you have to go for protection. So protection ಅಂತಂದ್ರೆ ಏನು? ನಿಮಗೆ ಏನೋ ಒಂದು ಸಿಕ್ಕಿದೆ, ಅದರಿಂದ ಲಾಭ ಆಗ್ತಾ ಇದೆ ಅನ್ನೋ ಸಿಚುವೇಶನ್ ಇದ್ರೆ ಮಾತ್ರ you have to go for protecting it legally. That is what we call it as copyright issues in the academic research. ನಾವು ಮನೆ, ಲ್ಯಾಂಡ್ ಅದೆಲ್ಲ ಫಿಸಿಕಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಹೋದ್ರೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಂತ ಕರಿತೀವಿ. ಬಟ್ ವೆನ್ ಇಟ್ ಕಮ್ಸ್ ಟು ದಿ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ರಿಸರ್ಚ್, ಎಸ್ಪೆಷಲಿ ಅಕಾಡೆಮಿಕ್ ರಿಸರ್ಚ್, then we call it as copyright issues. And these are the two things that we have to study all about in next few minutes, right? In the technical session 2. Before we go for that, we have to study something very small, interesting about intellectual property law. I know you have studied this in your first technical session, you have understood this, but without this I cannot go for my research topic. That's why I am going to explain the entire thing in only one slide. Before we go for this intellectual property law, you can split this into two terms: intellectual property law. Okay, I know what is a law. ಕಾನೂನಾತ್ಮಕ ರೀತಿಯಲ್ಲಿ ಅದು ಇರುತ್ತೆ, ಅದಕ್ಕೆ ಅದನ್ನ ಲಾ ಅಂತ ಕರಿತೀವಿ. ನೆಕ್ಸ್ಟ್, ಪ್ರಾಪರ್ಟಿ ಅಂತಂದ್ರೆ ಏನು? ಆಸ್ತಿ, ನಿನ್ನ ಹಕ್ಕು, ನಿನ್ನ ರೈಟ್, ಅದನ್ನ ನಾವು ಪ್ರಾಪರ್ಟಿ ಅಂತ ಕರಿತೀವಿ. ನೆಕ್ಸ್ಟ್, ದ ಫಸ್ಟ್ ದಟ್ ಈಸ್ ಇಂಟೆಲೆಕ್ಚುಯಲ್. ನೀವು ಕೆಲವು ಕಡೆ ಮಾತಾಡುವಾಗ ಕೇಳಿಸ್ಕೊಂಡಿರ್ಬೋದು, ಆ ಹುಡುಗ ಬಿಡು ಸಖತ್ ಇಂಟೆಲೆಕ್ಟ್ ಅವನು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ನಮ್ಮ ಭೀಮರಾವ್ ಅಂಬೇಡ್ಕರ್ ಅವರು, ಅಥವಾ ಅಬ್ದುಲ್ ಕಲಾಂ ಅವರು, ಸಾರಾಭಾಯ್ ಪಟೇಲ್ ಆಗಿರ್ಬೋದು, ಅಥವಾ ಸಿ ವಿ ರಾಮನ್ ಆಗಿರ್ಬೋದು, ಅವರೆಲ್ಲ ದೇ ಆರ್ ಗ್ರೇಟ್ ಇಂಟೆಲೆಕ್ಟ್ಸ್. ಏನಕ್ಕೆ? ವಾಟ್ ಮೇಡ್ ದೆಮ್ ಟು ಗೆಟ್ ಸಪರೇಟೆಡ್ ಫ್ರಮ್ ದಿ ರೆಸ್ಟ್ ಆಫ್ ದ ಪೀಪಲ್ ಇನ್ ದ ಕಂಟ್ರಿ? ಬಿಕಾಸ್ ದೇ ಹ್ಯಾವ್ ಗಾಟ್ ದೇರ್ ಓನ್ ಥಿಂಕಿಂಗ್, ದ ಕ್ರಿಯೇಟಿವ್ ಮೈಂಡ್ಸ್. ದೇ ಹ್ಯಾವ್ ಗಾಟ್ ದ ಕ್ರಿಯೇಟಿವ್ ಮೈಂಡ್ ವಿಚ್ ಈಸ್ ಸೂಪರ್ ದ್ಯಾನ್ ದಿ ನಾರ್ಮಲ್ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್. ನೀವೆಲ್ಲ ನೋಡ್ತಿರ್ಬೋದು, ಭೀಮರಾವ್ ಅಂಬೇಡ್ಕರ್ ಸಾಯಂಕಾಲ 6 ಗಂಟೆಗೆ ಬರ್ತಾ ಇದೆ. ಆ ಹುಡುಗ ಅಷ್ಟು ಚಿಕ್ಕ ವಯಸ್ಸಿನಲ್ಲಿ ಹೆಂಗೆ ಅಷ್ಟೊಂದೆಲ್ಲ ಯೋಚನೆ ಮಾಡಕ್ಕೆ ಸಾಧ್ಯ? That means to say, ಆ ಹುಡುಗಂಗೆ ಭೀಮರಾವ್ ಅಂಬೇಡ್ಕರ್ ಅವರು ಚಿಕ್ಕ ವಯಸ್ಸಾಗಿದ್ದಾಗ he has got extra super power. ಎರಡು ಯೋಚನೆ ಮಾಡೋದಕ್ಕಿಂತ ಒಂದು ಕೈ ಜಾಸ್ತಿನೇ ಯೋಚನೆ ಮಾಡಿರ್ತಾರೆ. ಅಂತವ್ರನ್ನ ನೀವು ಇಂಟೆಲೆಕ್ಟ್ ಅಂತ ಕರಿತೀರಾ. ಆ ಫಿನಾಮಿನನ್ನೇ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಅಂತ ಕರಿತೀರಾ. ಸೊ ಇಂಟೆಲೆಕ್ಚುಯಲ್, ಇಟ್ ಈಸ್ ಆಲ್ ಅಬೌಟ್ ದಿ ಎಬಿಲಿಟಿ ಟು ಥಿಂಕ್ ಅಂಡ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಐಡಿಯಾಸ್ ಅಟ್ ಎ ಹೈಯರ್ ಲೆವೆಲ್. ಈಗ ನಾನು ಅರ್ಥ ಮಾಡ್ಕೋತೀನಿ, ನೀವು ಅರ್ಥ ಮಾಡ್ಕೋತಾ ಇದ್ದೀರಾ. But if a person other than us, if he is thinking above us, then he is called as intellect, and that phenomenon is called as intellectual. So intellectual property law antandenu, it is something which you can persuade, and in the creation of a great variety of intellectual supplies. That means to say there is a law, ಕಾನೂನು ಒಂದಿದೆ. ಆ ಕಾನೂನಿನ ಅಡಿಯಲ್ಲಿ ನಮ್ಮ ಕ್ರಿಯೇಷನ್ಸ್ ನಮ್ಮ ಬುದ್ಧಿವಂತಿಕೆನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಕೋಬಹುದು. ಅದನ್ನ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ಲಾ ಅಂತ ನಾವು ಕರಿತೀವಿ. ರೈಟ್. ಈ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ಲಾ ಅನ್ನೋದು ಇಟ್ ಈಸ್ ಫಾರ್ ಓನ್ಲಿ ಎ ಲಿಮಿಟೆಡ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ನೀವೇನು ಇವಾಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಯಾವ್ದೊಂದು ಹ್ಯಾರ್ಲೆ ಡೇವಿಡ್ಸನ್ ಒಂದು ಬೈಕ್ ಕಂಡಿಡ್ದಿದ್ದಾರೆ. ರೈಟ್. ಆ ಬೈಕ್ ಕಂಡಿಡ್ದಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಅದ್ರ ಮೇಲೆ ದ ಓನರ್ ಆಫ್ ದ ಬೈಕ್, ನೀನ್ ದುಡ್ಡು ತಗೋತಾ ಇದ್ದೀರ, ನೀನಲ್ಲ ಓನರ್. ಆ ಓನರ್ ನಾವು ಇನ್ವೆಂಟರ್ ಅಂತ ಕರಿತೀವಿ. ವಾಟ್ ಈಸ್ ಇನ್ವೆಂಟರ್? ದ ಪರ್ಸನ್ ಹೂ ಇನ್ವೆಂಟ್ಸ್ ಅ ಪರ್ಟಿಕ್ಯುಲರ್ ಥಿಂಗ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಇನ್ವೆಂಟರ್. ಆ ಇನ್ವೆಂಟರ್ ನಮ್ಮ ಕಾನೂನಾತ್ಮಕ ರೀತಿಯಲ್ಲಿ he will have obtained the IP for that. That is intellectual property rights ನ ತಗೊಂಡಿರ್ತಾರೆ ಅವರು. ಆ ತಗೊಂಡಿರ್ತಾರೆ, ಅದನ್ನ ಅವರು ತಗೊಂಡಾದ್ಮೇಲೆ ರೈಟ್ಸ್ ನ ಬೇರೆಯವ್ರಿಗೆ ಮಾರ್ತಾರೆ, ಕಂಪನಿಗಳಿಗೆ ಮಾರ್ತಾರೆ. ಆ ಕಂಪನಿಗೆ ಮಾರ್ತಾರಲ್ಲ, ಆ ಮಾರೋ ಡ್ಯೂರೇಷನ್ ಇದೆಯಲ್ಲ, ಇಟ್ ವಿಲ್ ಬಿ ಫಾರ್ ಎ ಓನ್ಲಿ ರಿಸ್ಟ್ರಿಕ್ಟೆಡ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಒಂದು 10 ವರ್ಷಕ್ಕೋ 20 ವರ್ಷಕ್ಕೋ 30 ವರ್ಷಕ್ಕೋ ಲೀಸ್ ಅಂತ ಹಾಕೊಂಡಿರ್ತಾರೆ. ರೈಟ್. ಅಂಡ್ ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಫಾರ್ ಎ ಲಿಮಿಟೆಡ್ ಏರಿಯಾ ಆಫ್ time. Next, why you want to protect the law? Because you will see that whatever you get profit out of your creating mind. ನಿನ್ನ ಹತ್ರ ಏನೋ ಒಂದು ತಲೆ ಇದೆ, ನೀ ಏನೋ ಒಂದು ಕಂಡುಹಿಡಿತೀಯ. ಮೇ ಬಿ ಯು ವಿಲ್ ಡಿಸ್ಕವರ್ another vaccine tomorrow which is more superior than the existing vaccines today for coronavirus. Then that means to say the vaccine that you are going to find out will definitely bring profit to you. Because it is bringing profit to you, it gives a kind of economic enticement for their creation, right? And now this economic creation or the economic enticement, it will automatically lead to the progress of the country. So ultimately, whatever you invent, whatever you discover today, that is profiting not only you, but also it is profiting the country. In such cases, we always have to protect the law, right? That is called as intellectual property law. Mainly this intellectual property is divided into two categories. The first one is industrial property, next is the copyright. This is what I have to talk about, right? That's why I said without defining intellectual property, I cannot go for copyrights, because copyright is one of the types of intellectual property. Next, the first type is industrial property. Say for example, what are the things that comes under industrial property? It includes inventions or patents. So what is a patent? You have already definitely studied this in the first technical session. So patent is the one wherein you are protecting your product. For example, maybe in chemistry or biology or physics lab, you have discovered something which is great. And that greatness is bringing profit to you, and that profit, that research, with what you have done in the laboratory, you protect it in the form of patenting. That is one of the industrial products. The next one is the trademarks. Say for example, I have shown you several trademarks here: the Coca-Cola, Yahoo, the Nike. Simple tick mark. Nodili, only on the simple tick mark ide. That is protected by Nike. No other person can use that other than Nike, right? Because it has been trademarked. And Google and McDonald's, see, YouTube, all these are trademarks. That means they all have got the licenses. If you use that one, then you are going to be in trouble, definitely. That is the trademark. Next is the industrial designs. As I was telling you a short while ago, if you have invented a BMW car, even the fixation of the lights, the seating arrangement, the steering, everything has got a design, and nobody else can ಕಾಪಿ ದಟ್. ನೀವು ಸ್ವಲ್ಪ ವರ್ಷಗಳಿಂದ ಕೇಳಿರ್ಬೋದು, ಆಪಲ್ ಕಂಪ್ನಿನ ಬೇರೆ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು ಕಂಪನಿ ಒಂಚೂರು ಮಿಮಿಕ್ ಮಾಡ್ಬಿಡ್ತು ಮೊಬೈಲ್ ಅಲ್ಲಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಎಷ್ಟೋ ಲಕ್ಷ ಕೋಟಿ ಡಾಲರ್ಗಳು ಅವ್ರಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಅಂತ ಸಿಕ್ತು, ಅವ್ರಿಗೆ ಫೈನ್ ಅಂತ ಹಾಕಿದ್ರು ಅವ್ರಿಗೆ, ರೈಟ್? They are the live examples. So because they have involved in the infringement ಅಂತಂದ್ರೆ violation of the norms, violation of the rule. ನಾವು ಹೇಳಿರ್ತೀವಿ 10 ಗಂಟೆ ಒಳಗಡೆ ಕಾಲೇಜ್ ಬರ್ಬೇಕು ಅಂತ, 50, then it is a violation of the rule. ಅದೇ ತರ BMW car design, tire design ಹೀಗೆ ಇರಬೇಕು. If somebody is trying to copy the design, then that is the violation. Then that BMW car people, he can sue you for the violation of the acts. The next industrial properties, geographic indications of source, that is GI tag ಅಂತ ನಾವು ಕರೀತೀವಲ್ಲ ಹುಡುಗ. Few of the GI tags that have shown here, the whole India has got unique properties, the unique things that they have got. The one example is Mysore silk saree. It is from Mysore, and Mysore ಆಮೇಲೆ ಸಣ್ಣ ಪಟ್ಟದ ಹೋದ್ರೆ ಬೊಂಬೆಗಳು handicrafts. Right? They have got GI tags for that. Mysore silk ನ ಇಟ್ಕೊಂಡು ಇನ್ಯಾರೋ ಅಮೆರಿಕಾದಲ್ಲಿ ಕ್ಯಾಲಿಫೋರ್ನಿಯಾದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಹೋಗಿ ಕ್ಯಾಲಿಫೋರ್ನಿಯಾ ಸಿಲ್ಕ್ ಹಾಕಲ್ಲ, because the Mysore silk has obtained the GI tag and it has been protected. Somebody else cannot for that claiming the rights. Right? And if you want to have more geographic indications, you can definitely visit this link. You will be getting a lot of knowledge about the geographic indication, that is GI tags. Next, coming to the topic of interest, that is copyright. As I said, copyright, it is a type of intellectual property. Next, copyright, it is not only for the research. ನಾವು ಬರೀ ಏನು ಸೈನ್ಸ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಆರ್ಟ್ಸ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಕಾಮರ್ಸ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಹ್ಯುಮ್ಯಾನಿಟೀಸ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂದ್ರೆ ಬರೀ ಅಷ್ಟಕ್ಕಲ್ಲ. ಈವನ್ ದಿ ಆರ್ಟಿಸ್ಟ್, ಈಗ ಯಾರೊಬ್ರು ಕತೆ ಬರೆದ್ರು, ಡ್ರಾಮಾ ಬರೆದ್ರು, ಯಾರೊಬ್ರು ನಾವೆಲ್ ಪೊಯಮ್ಗಳು ಬರೆದ್ರು, and they can be protected, right? So this copyright, it includes literary artistic works like novels, poems, plays, ಡ್ರಾಮಾಗಳು, ಫಿಲ್ಮ್ಸ್, ಸಿನಿಮಾಗಳು ಬರೀತಾರೆ, ಕಥೆಗಳು, ಅದನ್ನು ಕೂಡ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಕಾಪಿರೈಟೆಡ್. ಬಿಕಾಸ್ ಯಾವನೊಬ್ಬ ಒಂದು ಸಿನಿಮಾ ತೆಗೆದಿರ್ತಾನೆ, ಅದೇ ತರ ಸಿನಿಮಾ ಒಂದು ಪಬ್ಲಿಷ್ ಮಾಡಕ್ ಮುಂಚೆ, ತೆರೆ ಮೇಲೆ ಬರಕ್ ಮುಂಚೆ ಇನ್ನೊಬ್ಬ ಸಿನಿಮಾ ಬಂದ್ಬಿಟ್ರೆ ಅವ್ನ ಕತೆ ಬರ್ದಿರೋನ್ಗೆ ಝೀರೋ ವ್ಯಾಲ್ಯೂ ಆಗೋಗ್ಬಿಡುತ್ತೆ. ಅದಕ್ಕೆ ಅವ್ನು ಏನ್ ಮಾಡ್ತಾನೆ, ಫಸ್ಟ್ as soon as he writes something, if he thinks it is different from the rest of the others that are available in the market, then he is going to protect that. ಆ ಪ್ರೊಟೆಕ್ಷನ್ ನಾವು ಕಾಪಿರೈಟ್ ಅಂತ ಕರಿತೀವಿ. ನೆಕ್ಸ್ಟ್, ಮ್ಯೂಸಿಕಲ್ ವರ್ಕ್ಸ್ ಇರ್ಬೋದು, ಯಾವ್ದಾದ್ರು ಒಂದು ಮ್ಯೂಸಿಕ್ ಮಾಡಿರ್ತೀರಾ ನೀವುಗಳು, if it is definitely different from others, you can copyright it. Then artistic works like drawings, there are several drawings in the world, Mona Lisa ಇರ್ಬೋದು ಅಥವಾ ರವಿ ವರ್ಮಾ ಇರ್ಬೋದು, they are all copyrighted. Paintings, photographs, sculptures, ಕೆತ್ತನೆ ಕೆಲಸಗಳಾಗಿರ್ಬೋದು, ಆರ್ಕಿಟೆಕ್ಚರಲ್ ಡಿಸೈನ್ಸ್. ಇವಾಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ನೀವು ಸುಮಾರೆಲ್ಲ ನೋಡ್ಬೋದು, ಬ್ರಿಗೇಡ್, ಪಾಮ್ ಗ್ರೂವ್ ಅವೆಲ್ಲನೂ ಹೆಂಗೆ they have got unique way of constructing the buildings. Then that is always protected because they have taken the license, they are protected. That's why you cannot copy them, right? These are all termed as copyright issues. Next, rights related to the copyright include those of performing artists in their performances. If somebody is enacting in a performance, in a drama, in a play or in a cinema, again that is copyrighted. And the producers of phonogram is a kind of ಮ್ಯೂಸಿಕ್. ಈಗ ನಮ್ಮ ಸ್ವರಗಳೆಲ್ಲ ಇರುತ್ತಲ್ಲ, ಅದನ್ನ ಸಾರಿಗ ಮಪ್ಪ ಅದನ್ನ ಸ್ವರಗಳನ್ನ ಮಿಕ್ಸ್ ಅಂಡ್ ಮ್ಯಾಚ್ ಮಾಡಿ ನಾವು ಏನೋ ಒಂದು ಬೇರೆ ಮ್ಯೂಸಿಕ್ ಮಾಡಿದ್ರೆ ದಟ್ ಇಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಫೋನೋಗ್ರಾಮ್. ಅಗೈನ್ ಫಾರ್ ದ ಮ್ಯೂಸಿಕ್ ಯು ಕ್ಯಾನ್ ಪ್ರೊಟೆಕ್ಟ್, ಅಂಡ್ ದೇರ್ ರೆಕಾರ್ಡಿಂಗ್ ಮಾಡೋದಕ್ಕೂ ಪ್ರೊಟೆಕ್ಷನ್ ಇರುತ್ತಂತೆ. ಅಂಡ್ ದೋಸ್ ಆಫ್ ಬ್ರಾಡ್ಕಾಸ್ಟರ್ಸ್ ಇನ್ ದ ರೇಡಿಯೋ ಆಸ್ ವೆಲ್ ಆಸ್ ದಿ ಟೆಲಿವಿಷನ್ ಪ್ರೋಗ್ರಾಮ್, ದ ಎಂಟೈರ್ ಥಿಂಗ್ ಈಸ್ protected. Why it is protected? Because they think that, they anticipate that their work is definitely helpful in getting the income for them. That is economic boosters. These are all economy boosters. Before going to the copyright issues as well as the research methodologies, you need to definitely know some of the terminologies that are associated with IPR and copyright issues. The first one is attribution. So what is attribution? That means you are giving credit to a person for the work he has done. ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ನೀವು ಇವಾಗ ವೆಬಿನಾರ್ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ನಿಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ನೀವು ಬ್ಯೂಟಿಫುಲ್ ಆಗಿ ಕಂಡಕ್ಟ್ ಮಾಡಿರ್ತೀರಾ ವೆಬಿನಾರ್ ನ. ನೆಕ್ಸ್ಟ್ ಯು ವಿಲ್ ಗೆಟ್ ದಿ ಅಪ್ರಿಸಿಯೇಷನ್ಸ್ ಫ್ರಮ್ ದ ಕಾಲೇಜ್, ಫ್ರಮ್ ದ ಮ್ಯಾನೇಜ್ಮೆಂಟ್, ಫ್ರಮ್ ದಿ ಸ್ಟೇಕ್ ಹೋಲ್ಡರ್ಸ್. ಬ್ಯೂಟಿಫುಲ್ ಆಗಿ ಆರ್ಗನೈಸ್ ಮಾಡಿದ್ರಿ, ದಟ್ ಈಸ್ ಗಿವಿಂಗ್ ಕ್ರೆಡಿಟ್ ಟು ದೇರ್ ವರ್ಕ್. ಅದೇ ತರನೇ ನಾನು ಇವಾಗ ಏನೋ ಒಂದು ಡಿಸ್ಕವರಿ ಮಾಡಿರ್ತೀನಿ, ಯಾವುದೋ ಒಂದು ಹೊಸ ಇನ್ವೆನ್ಷನ್ ಮಾಡಿರ್ತೀನಿ, ದಟ್ ಮೀನ್ಸ್ ಐ ಟೇಕ್ ಕ್ರೆಡಿಟ್ ಬಿಕಾಸ್ ಐ ಆಮ್ ದ ಇನ್ವೆಂಟರ್ ಆಫ್ ದಿಸ್. ಈಗ ನಾನೇನು ಡಿಸ್ಕವರಿ ಮಾಡ್ತೀನಿ, ಇದನ್ನ ಬೇರೊಬ್ಬ ಕಿತ್ಕೊಂಡ್ಬಿಟ್ಟು ಇದನ್ನ ಸುಹಾಸ್ ಏನು ಮಾಡಿಲ್ಲ, ಇಟ್ ಈಸ್ ದಿಸ್ ಪರ್ಸನ್ ಎಕ್ಸ್, ನಾನೇ ಇದನ್ನೆಲ್ಲ ಮಾಡಿದ್ದು ಅಂತ ಅನ್ಕೊಂಡ್ಬಿಟ್ರೆ ಐ ಆಮ್ ಅಂಡರ್ ಲಾಸ್. ದಟ್ ಮೀನ್ಸ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಬಿನ್ ಗಿವನ್ ಎನಿ ಕ್ರೆಡಿಟ್. ಸೊ ದಟ್ಸ್ ವೈ that attribution is always important in the research. Once it is attributed, the copyright comes into the picture. So what is copyright? ಇಷ್ಟೊತ್ತು ನಾವು ಕಾಪಿರೈಟ್ ಅಂತಂದ್ರೆ ಸುಮ್ಮನೆ ಪ್ರೊಟೆಕ್ಷನ್ ಅಂತ ಅನ್ಕೊಂಡಿದ್ವಿ, ಬಟ್ ಇಟ್ ಈಸ್ ಎ ಲೀಗಲ್ ಫಾರ್ಮ್ ಆಫ್ ಪ್ರೊಟೆಕ್ಷನ್. ಕಾನೂನಾತ್ಮಕ ರೀತಿಯಲ್ಲಿ ಅದಕ್ಕೆ ರಕ್ಷಣೆಯನ್ನ ಒದಗಿಸಿಕೊಟ್ಟಿರ್ತೀವಿ. ನೆಕ್ಸ್ಟ್, that right, that protection will be given to the creators of the original works of authorship. This is very, very important. Original works. If you are duplicating the work, then you cannot be given, you cannot be granted the copyright. If you have created something original, then definitely you are going to be copyrighted. Next, what is copyright infringement? Infringement, we all know that it is a violation. So ತಪ್ಪು ಮಾಡೋದು. ಇವಾಗ ನಾನು ಒಂದು ಮೊಬೈಲ್ ನ ಕಂಡುಹಿಡಿದಿದ್ದೀನಿ ಅಂತ ಅನ್ಕೊಳ್ಳೋಣ. ನನ್ನದೇ ಒಂದು ಓನ್ ಬ್ರ್ಯಾಂಡ್ ಅಲ್ಲಿ XYZ ಯಾವುದೋ ಒಂದು ಬ್ರ್ಯಾಂಡ್ ಇರ್ಬೋದು. ನಾನ್ ಮೊಬೈಲ್ ಕಂಡುಹಿಡಿದಿದ್ದೀನಿ ಅಂತ ಇನ್ನೊಬ್ಬ ಯಾವೊಬ್ಬರು ತೋರಿಸಿರ್ತೀನಿ ಅಂತ ಅನ್ಕೊಳ್ಳೋಣ. ಇವಾಗ ಓಕೆ, ಅವನು ನನ್ನ ಫ್ರೆಂಡ್ ಅದೊಂದು ಏನ್ ಮಾಡ್ತಾನೆ, ತಾಳು ಇವ್ನು ಕಂಡುಹಿಡಿದಿರೋದನ್ನ ನಾನೇ ಕಂಡುಹಿಡಿದಿದ್ದೀನಿ ಅಂತ ತೋರಿಸ್ಕೊಂಡು ಪಬ್ಲಿಸೈಸ್ ಆಗೋಗ್ತಾನೆ. ಅವನು ಸ್ಟೇಜ್ ಹತ್ತಾನೆ. ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಎಸ್ ನಾನೇ ಮಾಡಿರೋದು, ಇದು ನನ್ನದೇ ಇನ್ವೆನ್ಷನ್ ಇದು. ಅವಾಗ ಏನಾಗುತ್ತೆ, ಅವನದನ್ನ ಕಂಪ್ನಿಗೆ ಮಾರ್ಕೋತಾನೆ. ಸೊ ಯಾರಿಗ್ ಲಾಸ್ ಆಯ್ತು, ಯಾರಿಗ್ ಪ್ರಾಫಿಟ್ ಆಯ್ತು? ನನ್ನ ಫ್ರೆಂಡ್ಗೆ ಪ್ರಾಫಿಟ್ ಆಯ್ತು, ನನಗೆ ಲಾಸ್ ಆಯ್ತು. ದಟ್ ಈಸ್ ದಿ ವಯಲೇಷನ್. ವಯಲೇಷನ್ ಅಂತಂದ್ರೇನು? ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್. ಏನೋ ಒಂದು ರೂಲ್ ಇದೆ, ಆ ರೂಲ್ ನ ಫಾಲೋ ಮಾಡ್ಬೇಕು. ಆ ರೂಲ್ ನ ನಾವು ತದ್ವಿರುದ್ಧವಾಗಿ ಹೋಗ್ತಿದೀವಿ ಅಂತಂದ್ರೆ ವಯಲೇಟ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಅರ್ಥ. ಸೊ ಆಲ್ವೇಸ್ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಕಾಪಿ somebody's work, you should always obtain a permission from the original author. Only then you can copy the work. Otherwise it is called as copyright infringement. Infringement ಅನ್ನೋದು, violation ಅನ್ನೋದು, even it goes up to the ಜೈಲ್ ಹೋಗೋ ತನಕನೂ ನಡೆದಿದೆ. ಇದೆಲ್ಲ ಸುಮಾರು ಕೇಸ್ಗಳಲ್ಲಿ ನೀವು ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಅಥವಾ ಗೂಗಲ್ ಮಾಡಿ ನೋಡ್ಬೋದು. ನನಗೆ ಸಮಯದ ಅಭಾವ ಇರೋದ್ರಿಂದ and because of the paucity of time I'm not able to explain so many things here. I'm restricting myself. But definitely now everything is just a touch away. ನೀವು ಒಂದ್ಸರಿ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಟಚ್ ಮಾಡಿದ್ರೆ ಇಡೀ ಪ್ರಪಂಚನೇ ನೋಡ್ಬೋದು. It is definitely, you can see what are the problems that arises out of copyright infringement. Next is derivative work. ಏನಿದು ಡೆರಿವೇಟಿವ್ ಅಂತಂದ್ರೆ, ಈಗ ಯಾರೋ ಒಬ್ರು ಏನೋ ಮಾಡಿರ್ತಾರೆ, ಅದರದ್ದು ಕಂಟಿನ್ಯೂಯೇಷನ್ ಮಾಡ್ಕೊಂಡು ಹೋಗೋದು ನಾವು. ಅಗೇನ್ ದಟ್ ಈಸ್ ನಾಟ್ ಅಲೌಡ್ ಇನ್ ದಿ ಕಾಪಿರೈಟ್. ಅನ್ಲೆಸ್ ಯು ಹ್ಯಾವ್ ದ ಪರ್ಮಿಷನ್, ಯು ಕ್ಯಾನಾಟ್ ಈವನ್ ಮೇಕ್ ಎ ಡೆರಿವೇಟಿವ್ ಆಫ್ ದ ವರ್ಕ್. ಸೇ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಯಾವನೊಬ್ಬ ಹೊಸ ಬ್ರ್ಯಾಂಡ್ ಶರ್ಟ್ ನ ಕಂಡುಹಿಡಿದಿರ್ತಾರೆ ಯಾವ್ದೋ ಕಂಪನಿಯವರು. ಇನ್ನೊಬ್ಬ ಕಂಪನಿಯವರು ಅದೇ ತರ ಶರ್ಟ್ ಮಾಡಿರ್ತಾನೆ. ಆ ಶರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಏನೋ ಒಂಚೂರು ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿರ್ತಾನೆ ಆ ಶರ್ಟ್ ಅಲ್ಲಿ ಅಷ್ಟೇ, ಯಾವ್ದೋ ಒಂದು ಕಲರ್ ಅಥವಾ ಏನೋ ಒಂದು ಸಿಂಬಲ್ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿರ್ತಾನೆ. ಏನಂತ ಕರಿತೀವಿ ನಾವು? ಡೆರಿವೇಟಿವ್ ಆಫ್ ದ ವರ್ಕ್. ಅಂಡ್ ಈವನ್ ದಟ್ ಈಸ್ ನಾಟ್ ಅಲೌಡ್ ಇನ್ ದಿ ಕಾಪಿರೈಟ್ ಇಶ್ಯೂಸ್, ಬಿಕಾಸ್ that is just a translation or transformation of one or more original copyrighted works. Next is fair use. ಫೇರ್ ಅಂತಂದ್ರೇನು? ಒಳ್ಳೆ ರೀತಿಯಲ್ಲಿ. ಯೂಸ್ ಅಂತಂದ್ರೆ ಉಪಯೋಗ. ಒಳ್ಳೆ ರೀತಿಯಲ್ಲಿ ಉಪಯೋಗ ಮಾಡೋದನ್ನ ನಾವು ಫೇರ್ ಯೂಸ್ ಅಂತ ಕರಿತೀವಿ. ಸೊ ವಾಟ್ ಡಸ್ ದಿಸ್ ಡೂ? ಫೇರ್ ಯೂಸ್, ಇಟ್ ಪರ್ಮಿಟ್ಸ್ ಎ ಸೆಕೆಂಡ್ ಯೂಸರ್ ಟು ಕಾಪಿ a part of the copyrighted work or the whole of the copyrighted work without even the taking permission from the original contributor or original owner. That is called as fair use. Usually fair use is used in education. Even in teachers, especially during this pandemic, naವೆಲ್ಲ ಆನ್ಲೈನ್ ಟೀಚಿಂಗ್ ಗೆ ಮಾಡ್ತಾ ಇರೋದು ನಾವು. ಆನ್ಲೈನ್ ಟೀಚಿಂಗ್ ಅಲ್ಲಿ, say for example, if you want to explain some topic, definitely you will take up some images from the Google. So if you are taking that image Google, and if it is used for a particular purpose, that is for the education purpose, for teaching the students, then you don't have to obtain permission for using that image from the original inventor. So in such cases, that is called as fair use. Next is intellectual property. It is nothing but creations of the mind. ನಿನ್ನ ಬುದ್ಧಿವಂತಿಕೆ, ಮಾಮೂಲಿ ಬುದ್ಧಿವಂತಿಕೆ ಅಲ್ಲ, ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಬುದ್ಧಿವಂತಿಕೆಯಿಂದ ಬರೋದನ್ನ ಹೊರಹೊಮ್ಮುತ್ತಲ್ಲ. ಏನಾದ್ರು ಒಂದು ಪ್ರಾಡಕ್ಟ್ ನ, ಅದನ್ನ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಕರಿತೀವಿ. ನೆಕ್ಸ್ಟ್ ಲೈಸೆನ್ಸ್. ಏನು ಲೈಸೆನ್ಸ್ ಅಂತಂದ್ರೆ ಪರ್ಮಿಷನ್. ಆಯ್ತು, ಈಗ ಲೈಸೆನ್ಸ್ ಎಲ್ಲೆಲ್ಲ ಸಿಕ್ತು, DL ಸಿಕ್ತು ಅಂತ ಅಂತೀರಾ. ಸೊ ವಾಟ್ ಇಸ್ ದಟ್? ಇಟ್ ಇಸ್ ನಥಿಂಗ್ ಬಟ್ obtaining the permission to do some work. But in this case, it is permission to use a creative work. You have to always obtain the license if you want to reuse the work. Next, coming to the hot topic, copyright. Right. So this copyright, it gives a right, or it grants the right to the artificer of distinctive work. See this word carefully. the work should be very different from the others. If you keep on doing the same work, then you cannot have or you cannot claim any rights on that work. That work should be entirely different, distinctive from others, and also for its use as well as the allocation. And this copyright is only for a particular period of time. But after some time, that product may not be useful, so you cannot have the copyright for the rest for the entire life. It is not like that. It is for like 5 years, 10 years, 15 years. That means like a lease agreement. We are going to have the copyrights. Next, this copyrights, it don't seems to be absolute, but you will have always some restricted limitations and exceptions for the copyright law as well as simply use. ನಿಮಗೆ ಒಂದು ಕಾಪಿರೈಟ್ ಇದೆ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಅದರದೇ ಆದಂತ ಒಂದು ಲಿಮಿಟೇಷನ್ಗಳಿದಾವೆ, ನ್ಯೂನ್ಯತೆಗಳಿದಾವೆ. ಸುಮ್ಮನೆ ಕಾಪಿರೈಟ್ ಸಿಕ್ತು ಅಂದ್ಬಿಟ್ಟು ನೀನ್ ಏನೋ ಏನೇನೋ ಮಾಡ್ಬಿಡ್ತೀನಿ ಅಂದ್ರೆ ದಟ್ ಇಸ್ ಆಲ್ಸೋ ನಾಟ್ ಪಾಸಿಬಲ್, ಬಿಕಾಸ್ ದೇರ್ ಆರ್ ಸಮ್ ಲಿಮಿಟೇಷನ್ ದಟ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಕಸ್ ಇನ್ ಎ ಶಾರ್ಟ್ ವೈಲ್ ಫ್ರಮ್ ನೌ. But one of the main limitations on copyright is that it protects only the distinctive expression of ideas and not the underlying ideas themselves. So, ನೀವಾಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಯಾರೋ ಒಬ್ರು ರಾಕೆಟ್ ಕಂಡಿಡಿದಿದ್ದಾರೆ ಅಂತ ಅನ್ಕೊಳ್ಳೋಣ. ಆ ರಾಕೆಟ್ ಕಂಡಿಡ್ದಿರಲ್ಲ, ಆ ರಾಕೆಟ್ ಕಂಡಿಡ್ದಿರೋದಕ್ಕೆ ಆ ಟೆಕ್ನಾಲಜಿಗೆ ಕಾಪಿರೈಟ್ ಸಿಗತ್ತೆ ಹೊರತು ಆ ವ್ಯಕ್ತಿಗೆ ಯಾವುದೇ ತರಹದ ಪ್ರೊಟೆಕ್ಷನ್ ಲೀಗಲಿ ಸಿಗಲ್ಲ. ಕಾಪಿರೈಟ್ ಇಸ್ ಓನ್ಲಿ ಫಾರ್ ದಿ ಐಟಮ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಡಿಸ್ಕವರ್ಡ್ ಅಂಡ್ ನಾಟ್ ಫಾರ್ ದಿ ಅಂಡರ್ಲೈಂಗ್ ಐಡಿಯಾಸ್ themselves. So copyright, it can be either for the author, you can protect it, you have got a law, ಕಾನೂನಾತ್ಮಕ ರೀತಿಯಲ್ಲಿ ತಗೋಬೇಕು, and you can patent it, you can register it, ಅಂದ್ರೆ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅದೆಲ್ಲ ಬಂದಾಗ ನಾವು ರಿಜಿಸ್ಟರ್ ಅಂತ ಕರಿತೀವಿ. You have to obtain the license, that is again a copyright. Then if you have got a creative idea, you can go for the copywriting. If you have the property, then again we will go for the copyright. ಅಂದ್ರೆ ಏನರ್ಥ, ನಿನ್ನದೇ ಒಂದು ಸ್ವಂತಿಕೆ ಅಂತ ಇದ್ರೆ, ಆ ಸ್ವಂತಿಕೆಯಿಂದ ನಿನಗೇನಾದ್ರೂ ಒಂದು ಲಾಭ ಅಂತ ಇದ್ರೆ, ಡೆಫಿನೆಟ್ಲಿ ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಫಾರ್ ದಿ ಕಾಪಿರೈಟ್. That is all about the copyright. Now we will go for the academic research. So this academic research, it is mainly on the cautious study of a specific topic or field or crisis. There are many fellow teachers attending the webinar. You must have experience. So research means I cannot simply just say Kannada. There are several subtopics in Kannada. Subtopics, subtopics. There are several titles. There are several topics, and you can concentrate only one particular topic. And you have to study extensively on that particular topic. So if you are doing that study cautiously, carefully, that is called as academic research. And you should have some fundamental facts and principles for the discovery that you have done. Next, whenever I talk about academic research, definitely there will be a copyright issue. So automatically, whenever I say academic research, copyright issues arises. So when you search for a particular work in like articles, we find that some of the articles are copyrighted, whereas some of the articles are not copyrighted. If there are teachers who are pursuing PhD or finished PhD, you will understand this. But for the students, you will see that if you want to access some article, those articles, they are protected. That means you cannot simply download the articles. You have to pay for the publisher for getting the original script or preprint of the article. Next, an author, ನೀವು ವರ್ಕ್ ಮಾಡಿದ್ದೆಲ್ಲನೂ ಕಾಪಿರೈಟ್ ಆಗಬೇಕು ಅನ್ನೋದು ಸುಳ್ಳು. ಕೆಲವ್ರದ್ದು ಕಾಪಿರೈಟ್ ಮಾಡ್ತೀವಿ, ಕೆಲವ್ರದ್ದು ಕಾಪಿರೈಟ್ ಮಾಡಲ್ಲ. ಇಟ್ ಆಲ್ ಡಿಪೆಂಡ್ಸ್ ಆನ್ ದಿ ಒರಿಜಿನಾಲಿಟಿ ಆಫ್ ದಿ ವರ್ಕ್. Next, do we have any laws for this copyright? Definitely, there are some acts which governs the copyright, and this Copyright Act was first brought into existence in the year 1957, and it describes the subject matter of copyright laws in India and other countries. We have got several copyright issues. As far as India is concerned, the first Copyright Act was put into force in the year 1957. It came into existence in India in the year 1958 from 21st January. But before that, we can think, did we have this Copyright Act? Yes, we had during the colonial era, that is in the during British Empire, we had the copyright issues. But after the obtaining the independence, the first act pertaining to copyright was in the year 1957. And since the inception, the year 1957, this Copyright Act has been amended 6 times. Amendment ಗಳಂತಂದ್ರೆ ಏನು? ತಿದ್ದುಪಡಿಗಳು. ನನಗೆ ಫಸ್ಟ್ ಮಾಡಿದಾಗ ಏನೋ ಇವಾಗ ನೀವು ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಯಾವುದೋ ಒಂದು ಮನೆ ಕಟ್ಟಿಸ್ತಾ ಇರ್ತೀರಾ, ಫಸ್ಟ್ ಒಂದು ಪ್ಲಾನ್ ಅಂತ ಹಾಕ್ತೀರಾ, ಬಟ್ ವೆನ್ ಯು ಸ್ಟಾರ್ಟ್ ಕನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಡೆಫಿನೆಟ್ಲಿ ದ ಪ್ಲಾನ್ ಚೇಂಜಸ್. ಫಸ್ಟ್ ಪ್ಲಾನ್, ಸೆಕೆಂಡ್ ಪ್ಲಾನ್, ಥರ್ಡ್ ಪ್ಲಾನ್, ಫೋರ್ತ್ ಪ್ಲಾನ್ ಅಂತ ಪ್ಲಾನ್ಗಳು ಚೇಂಜ್ ಆಗ್ತಾ ಹೋಗ್ತಾ ಇರುತ್ತೆ. ದೇ ಆರ್ ಕಾಲ್ಡ್ ಆಸ್ ಅಮೆಂಡ್ಮೆಂಟ್ಸ್. ಸೊ ನಮ್ಮ ಕಾಪಿರೈಟ್ ಆಕ್ಟ್ 1957ಗೆ 6 ಸರಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಗಳಾಗಿದೆ. ಅಂಡ್ ದ ಲೇಟೆಸ್ಟ್ amendment was in the year 2012, right? And that is called as Copyright Amendment Act 2012. And if you want to go to this Copyright Act 1957, you can definitely click on this link where PDF is available. Next, we have learned about academic research, we have learned about copyright issues. Now we have to learn about the ಪಬ್ಲಿಕೇಶನ್. ಏನು ಪಬ್ಲಿಕೇಶನ್ ಮಾಡೋದು, ಪ್ರಕಟಣೆ ಮಾಡೋದು. ಏನೆಲ್ಲ ಪ್ರಕಟಣೆ ಮಾಡ್ತೀವಿ ನಾವು? ದಿನ ಮಾಡೋದನ್ನೆಲ್ಲ ಪ್ರಕಟಣೆ ಮಾಡಕ್ಕಾಗುತ್ತಾ? ಈಗ ಪುಸ್ತಕಗಳನ್ನ ಪ್ರಕಟಣೆ ಮಾಡ್ತಾರೆ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಸುಧಾ ಇದೆ, ಮ್ಯಾಗಝೈನ್, ತರಂಗ ಇದೆ, ಅದೆಲ್ಲ ಪಬ್ಲಿಷ್ ಆಗುತ್ತೆ. ಯಾಕೆ? ಅದ್ರಲ್ಲಿ ಏನೋ ಒಂದು ಹೊಸತ್ತಿರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಯಾವ್ದೋ ಒಬ್ರು ಕತೆ ಬರ್ದಿರ್ತಾರೆ, ಆ ಕತೆ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ SL ಭೈರಪ್ಪ ಅವ್ರದ್ದು ಬೇಕಾದಷ್ಟು ಕೃತಿಗಳಿದ್ದಾವೆ, ಅವರೆಲ್ಲ ಪ್ರಕಟಣೆ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ. ಈ ಕವಿಗಳೆಲ್ಲ ಸಾಹಿತ್ಯಗಳು ಬರೆದಿರೋದನ್ನ ತಮ್ಮಷ್ಟಕ್ಕೆ ನಾವು ಇಟ್ಕೊಳ್ಳಲ್ಲ. ದೇ ವಿಲ್ ಗೋ ಫಾರ್ ದಿ ಪಬ್ಲಿಸೈಸಿಂಗ್ ದೇರ್ ವರ್ಕ್. ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಪಬ್ಲಿಕೇಶನ್. ಬರೀ ಸಾಹಿತ್ಯದಲ್ಲಿ ಅಥವಾ ಅಕಾಡೆಮಿಕ್ಸ್ ಅಲ್ಲಿ ಮಾತ್ರ ಪ್ರಕಟಣೆ ಅಥವಾ ಪಬ್ಲಿಕೇಶನ್ ಬರಲ್ಲ. ಈವನ್ ಇಟ್ ಕಮ್ಸ್ ಇನ್ ಲಿಟರರಿ, ಡ್ರಾಮಾ, ಮ್ಯೂಸಿಕ್, ಆರ್ಟಿಸ್ಟಿಕ್ ವರ್ಕ್, wherein they are going to copy the work to the people in adequate quantities. They will make the people to get these prints in suitable quantity. ನೀವು ಒಂದು ಬುಕ್ ನೋಡಿ 10,000 copies, 20,000 copies ಅಥವಾ most selling book ಅಂತೆಲ್ಲ ಇರುತ್ತೆ. That means they are making the book or they are making the product easily available to the public. That is called as publication. And not only to this, even you can have in the cinematograph film. Even there, for example, when a film is released into theaters, you buy tickets and you watch it. If you do not want to go to theaters, you can sit at home. You can go to some websites like Netflix, Amazon. We have got n number of websites. You have to subscribe by paying some money, and you can watch films. And against this, you must have heard about pirated CDs. ಅಂದ್ರೆ ಏನು? ಕಳ್ಳತನದಲ್ಲಿ ಆ ಫಿಲಮ್ದು ಒಂದು ಕಾಪಿ ತಗೊಂಡು ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಅದನ್ನ ಪೈರಸಿ ಕರೀತಾರೆ. That is called copyright infringement. They are violating the law. And even the publication can be in terms of a case of a record. So the record should be made available to the public in adequate quantities. ಇದಿಷ್ಟಿದೆ ಅಂತಂದ್ರೆ ಇಷ್ಟಕ್ಕೆ ಸೀಮಿತವಾಗಿರ್ಬೋದು. 10,000 ಕಾಪೀಸ್ ಮಾಡಿಸಿದ್ಯಾ ಈ ವರ್ಷ, ಮುಂದಿನ ವರ್ಷ ಇನ್ನು 10,000 ಕಾಪೀಸ್ ಮಾಡಿಸು. That means you should make the people get these products in adequate quantities. So what can be the publication formats? It can be magazines or journals, it can be newspapers, websites, blogs, podcasts, documentaries, online videos, conference presentation, articles and books. These are different publication formats. Next, meaning of ಕಾಪಿರೈಟ್. ಕಾಪಿರೈಟ್ ಅಂತಂದ್ರೆ ನಾವು ಪ್ರೊಟೆಕ್ಷನ್ ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ವಿ, ಡೆಫಿನೇಷನ್ ಮಾಡಿದ್ವಿ. ಬಟ್ ಇನ್ ಡೆಪ್ತ್ ಅನಾಲಿಸಿಸ್ ಹೋದಾಗ ನಮ್ಗೆ ಏನಾಗುತ್ತೆ? ವಾಟ್ ಈಸ್ ಕಾಪಿರೈಟ್? ಇಟ್ ಶುಡ್ ಬಿ ಏಬಲ್ ಟು ರಿಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಎನಿ ವರ್ಕ್ ಇನ್ ಎನಿ ಮೆಟೀರಿಯಲ್ ಫಾರ್ಮ್. ಈ ಕಾಪಿರೈಟ್ ತಗೊಂಡಿದ್ಯಾ ಅಂತಂದ್ರೆ ಅದ್ರದ್ದು ನೀನು ಬೇರೆಯವ್ರಿಗೆ ಕಾಪಿರೈಟ್ ಪಾಸ್ ಮಾಡ್ತಾ ಇದೀಯ ಅಂತಂದ್ರೆ ದೇ ಶುಡ್ ಬಿ ಏಬಲ್ ಟು ರಿಪ್ರೊಡ್ಯೂಸ್ ದ ವರ್ಕ್ ಇನ್ ಎನಿ ಮೆಟೀರಿಯಲ್ ಫಾರ್ಮ್. ದೇ ಹ್ಯಾವ್ ಟು ಬಿ ಪಬ್ಲಿಷ್ ದ ವರ್ಕ್. They have to perform the work in the public. ನಾನು ಮಾಡ್ಕೊಂಡು ಮನೆಯಲ್ಲಿ ಅಥವಾ ಲ್ಯಾಬ್ ಮಾಡ್ಕೊಂಡು ನನ್ನಷ್ಟಕ್ಕೆ ಇಟ್ಕೋತೀನಿ ಅಂತಂದ್ರೆ ಅದನ್ನ ಕಾಪಿರೈಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. You should always make it available to the public. And also with regards to producing, reproducing, performing and publishing any translation of the work, that can all be done when you take the copyrights from the owner. And the communication of the work by radio diffusion or communication through loudspeakers to the public, that can also be copyrighted. And any adaptation of the work, so ಯಾರೋ ಒಬ್ರು ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೋಬೇಕು, ಅದನ್ನ ವರ್ಕ್ ನ ಬೇಸಿಸ್ ಆಗಿ ಇಟ್ಕೊಂಡು ನಾನು ಹೈಯರ್ ಕಾನ್ಸೆಪ್ಟ್ಸ್ ಹೋಗ್ಬೇಕು ಅಂತಂದ್ರೆ again you have to obtain the copyright from them. That means you have to pay some money and you have to get the permission for its reuse and also for the translation as well as adaptation of the work in any form. This is the in-depth meaning of copyright. ನೆಕ್ಸ್ಟ್ ನಾನು ಯಾವ್ದೋ ಒಬ್ರದ್ದು ಒರಿಜಿನಲ್ ವರ್ಕ್ ಇದೆ, ನಾನು ಅದನ್ನ ಕಾಪಿ ಮಾಡ್ಬೇಕು, ಅದನ್ನ ಅಥವಾ ಅದರಿಂದ ನಾನು ಸ್ವಲ್ಪ ಭಾಗನ ತಗೋಬೇಕು ಅಂತಂದ್ರೆ ಏನು, ಸುಮ್ಮನೆ ನಾನು ಕೇಳ್ಬಿಟ್ಟು ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಅಥವಾ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಮಾಡ್ಬಿಟ್ಟು ಆಗೋಗುತ್ತಾ? ಇಟ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್. ಎವ್ರಿಥಿಂಗ್ ಶುಡ್ ಬಿ ಇನ್ ದಿ ರಿಟರ್ನ್ ಡಾಕ್ಯುಮೆಂಟ್. ಈಗ ಮನೆಗಳಲ್ಲಿ ನೀವು ನೋಡಿರ್ತೀರಾ ಅಥವಾ ಫಿಲಂಗಳಲ್ಲಿ, ಸೀರಿಯಲ್ಗಳೆಲ್ಲ, ಯು ವಿಲ್ ಹಾವ್ ಡೆಫಿನೆಟ್ಲಿ ಕಮ್ ಅಕ್ರಾಸ್ ದಿಸ್. ಯಾರೊಬ್ರು ಹೇಳಿರ್ತಾರೆ, ಓಕೆ ನಾನು ಹೋದ್ಮೇಲೆ ಈ ಮನೆ ನಿಂದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಅವ್ರಿಗೆ 5 ಜನ ಮಕ್ಳಿರ್ತಾರೆ, ಮೊದಲನೇ ಮಗನಿಗೋ ಮಧ್ಯದವನಿಗೋ ಯಾವನ್ಗೋ ಈ ಮನೆ ನಿನಗೆನೆ ನಾನು ತೀರ್ಕೊಂಡಾದ್ಮೇಲೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಸುಮ್ನೆ ಓರಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಅವನು ಪಾಪ ಅವರು XYZ ಅಪ್ಪ ಅಮ್ಮ ಯಾರೋ ಇರ್ತಾರೆ, ಅವರು ಕಾಲವಾಗಿ ಹೋಗ್ತಾರೆ. ಕಾಲವಾದ್ಮೇಲೆ ಇವ್ರಿಗೆ ಹೇಳಿರ್ತಾನಲ್ಲ ಮಗ, ಅವ್ನು ಬಂದು ಕ್ಲೈಮ್ ಮಾಡ್ತಾನೆ, ಅಮ್ಮ ನಂಗೆ ಇರುವಾಗ್ಲೇ ಬದುಕಿರುವಾಗ್ಲೇ ಹೇಳಿದ್ರು ಈ ಮನೆ ನನಗೆ ಅಂತೆ. ಡಸ್ ಎನಿಬಡಿ ಬಿಲೀವ್? ದೊಡ್ಡ ಮಗನು ಬಂದು ಹೇಳ್ತಾರೆ, ಇಲ್ಲ ಇಲ್ಲ ಅಮ್ಮ ನನಗೂ ಹೇಳಿದ್ರು ಈ ಮನೆ ನನಗೆ ಅಂತ. ಇನ್ನ 5 ಜನ ಇರೋರ ಮಧ್ಯದಲ್ಲಿ ಅವರು ಬಂದು ಹೇಳಿದ್ರು ನನಗೆ ಅಂತ. ದಟ್ ಮೀನ್ಸ್ ಓರಲಿ ನಥಿಂಗ್ ಈಸ್ ಅಕ್ಸೆಪ್ಟಬಲ್. ಎವ್ರಿಥಿಂಗ್ ಶುಡ್ ಬಿ ಡಾಕ್ಯುಮೆಂಟೆಡ್, ರೈಟ್? ಅಂಡ್ ಆಫ್ಟರ್ ದ ಡಾಕ್ಯುಮೆಂಟೇಶನ್ ಸುಮ್ಮನೆ ಬರ್ದ್ಬಿಟ್ರೆ ಸಾಲಲ್ಲ, ಬರ್ದಾದ್ಮೇಲೆ ಸಿಗ್ನೇಚರ್ ಇರಬೇಕು. ರೈಟಿಂಗ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಆಸ್ ವೆಲ್ ಆಸ್ ಸೈನಿಂಗ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ becomes very very important in the copyright transfer agreement. So if you are transferring the copyright from one person to other person, you should see that that is in writing, and also there should be a affix of the signature. If there is no signature, ನಾನು ಬರ್ಕೊಂಡು ಒಂದು ಖಾಲಿ ಪೇಪರ್ ಮೇಲೆ ತೋರಿಸ್ಕೊಡ್ಬೋದು ಈ ಆಸ್ತಿ ನಂದು ಅಂತ. Does anyone agree? Never. ರಿಟರ್ನ್ ಅಲ್ಲಿ ಇರಬೇಕು, ಸೈನ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೂಡ ಇರಬೇಕು. ದಟ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಶೋನ್ ಹಿಯರ್. See, something should be in written form as well as there should be affixture of the signature. Only then you can transfer of the right on a non-exclusive basis. It does not require any kind of written agreement. ಕೆಲವೊಂದು ಇನ್ಸ್ಟೆನ್ಸಸ್ ಅಲ್ಲಿ, ಕೆಲವೊಂದು ಎಕ್ಸಾಂಪಲ್ಸ್ ಅಲ್ಲಿ ರಿಟರ್ನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅವಶ್ಯಕತೆ ಇರೋದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್, when it comes to the academic research, say for example you will carry out this beautiful research and you want to publish it in some journal. Now adana paper anta karitive, but paper anadu, it is not a technical word, not a suitable word. We have to call it as a research article. So if you want to publish that research article, then you will go for a publisher. ನೀವು ಏನು ಮಾಡ್ತೀರಾ, ವರ್ಕ್ ಎಲ್ಲ ಮುಗಿತು, ಬರೀತೀರಾ ಮ್ಯಾನುಸ್ಕ್ರಿಪ್ಟ್ ಬರ್ದಿದ್ದನ್ನ ನೀವು ಹಾಕ್ತೀರಾ ಪಬ್ಲಿಷರ್ಗೆ, ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ. ಆ ಪಬ್ಲಿಷರ್ ರಿವ್ಯೂರ್ಗೆಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟು, yes, if the paper is found to be suitable, then definitely he will say that yes, we have accepted your manuscript and it will be published in our journal ಅಂತ ಹೇಳ್ತಾನೆ. Next, if you are publishing in that journal, there should be an agreement between the author. See, this is the author and these are some of the journals. So between author and journals, you will see that there should be a publishing agreement. If and only if there is a publishing agreement, you will see that everything is in the written document. So before an article is published in any journal or before a contribution to an academic textbook is published, there should be a publishing agreement between the author as well as the publisher. And this entails an assignment of copyright or exclusive dissemination rights. So this is the author, ಅವನೇ ಅದರದ್ದು ಒರಿಜಿನಲ್ ಇನ್ವೆಂಟರ್. ಈ ಆಥರ್ ಏನಾದ್ರೂ ಪಬ್ಲಿಷ್ ಮಾಡಬೇಕು ಅಂತಂದ್ರೆ ಪಬ್ಲಿಷರ್ಸ್ ಜೊತೆಗೆ there should be a written publishing agreement. So once an agreement ಆದ್ರೆ, there are different types of agreement, publishing agreement, that I'm going to explain you in a short while time from now, and everything should be in the written document only, right? So an assignment always, it transfers the copyright from author to the publisher. So there are two types of giving the agreement. One is license, another one is assignment. So what is licensing? Licensing ಅಂತಂದ್ರೆ you have given the rights partially. ಸ್ವಲ್ಪ rights ಮಾತ್ರ ನೀವು ಕೊಟ್ಟಿದ್ಯಾ. Maybe you can reproduce your work in conference. Maybe you can use this for your teaching. ಕೆಲವು ರೈಟ್ಸ್ ಮಾತ್ರ ನಿಮಗೆ ಪಬ್ಲಿಷರ್ ನಿಮಗೆ ಕೊಟ್ಟಿರ್ತಾರೆ. ಬಟ್ ಅಸೈನ್ಮೆಂಟ್ ಅಂತಂದ್ರೆ ಏನು, ಆಥರ್ಸ್ ವಿಲ್ ಹ್ಯಾವ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್ ದ ಕಂಪ್ಲೀಟ್ ರೈಟ್ಸ್ ಟು ದಿ ಪಬ್ಲಿಷರ್. See here, I have given the definition. The main difference between assignments and licenses is that license, it allows the licensor to maintain the rights and interest in their IP. So it is a partial kind of thing. Whereas the assignment, it transfers all of the assigner rights to their IP and assigns it to the assignee. That means if you are an author and if you are publishing an article in the publisher, a reputed publisher, then you are transferring the entire rights. ನಿನ್ನ ಹಕ್ಕುಗಳನ್ನೆಲ್ಲನೂ ನೀನು ಪಬ್ಲಿಷರ್ ಮೇಲೆ ಕೊಟ್ಟು ಬಿಡ್ತಾ ಇದೀಯಾ. ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಅಸೈನ್ಮೆಂಟ್ ಅಥವಾ ಲೈಸೆನ್ಸ್. ಅಂದ್ರೆ ಏನು, ನಿನ್ನ ತಾನೇ ಹಕ್ಕಿರತ್ತೆ, ನೀನು ಪಾರ್ಷಿಯಲಿ ಯು ಆರ್ ಗಿವಿಂಗ್ ಇಟ್ ಟು ದಿ ಪಬ್ಲಿಷರ್. ನಿನ್ನ ತಾನೇ ಸ್ವಲ್ಪ ಹಕ್ಕಿರತ್ತೆ, ಪಬ್ಲಿಷರ್ ಕೂಡ ಸ್ವಲ್ಪ ಹಕ್ಕಿರತ್ತೆ. ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಲೈಸೆನ್ಸಿಂಗ್. Next, we have to know about the open access journals. Before, we never used to have open access journals. Say a decade ago, when we were doing the research in the late 2010, we did not have research open access journals at all. We had to pay money, or we had to go for some licensing agreements between the university and the publisher. But nowadays, these open access journals are mushrooming like anything. There are a lot of benefits of this open access. So once ನೋಡಿ, ಕೀ ಓಪನ್ ಆಗಿದೆ ಅಂತ ಅರ್ಥ. ಏನು ಕೀ ಓಪನ್ ಆಗಿದೆ? That means anybody can go and access that article, can go and access that particular work. That is known as open access. So the journals which give open access, they are called as open access journals. So this open access journals, what it does is, it will allow the authors to retain copyright, or sometimes they will ask to transfer entire rights to the publisher. But in either case, you will see that the copyright holder now, it can be either author or the publisher. So they will have to obtain the consent to open the access of the published work. Once if the publisher, he holds the copyright, then it will consent to open access directly. So if you are ನಿನ್ನ ಹಕ್ಕುಗಳೆಲ್ಲನೂ ನೀನು ಪಬ್ಲಿಷರ್ ಕೊಟ್ಟುಬಿಟ್ಟಿದ್ಯಾ ಅಂತಂದ್ರೆ, ಆ ಪಬ್ಲಿಷರ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಅವರ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಆರ್ಟಿಕಲ್ ನ ಓಪನ್ ಆಕ್ಸೆಸ್, this paper or this article can be accessed by anyone in the world. That is known as open access journals. Sometimes the journal is not accessible for everyone, whereas some of the articles are accessible because that comes under open access system. But in some journals, the entire papers, all the research articles are accessible by everyone in the world. That is known as open access journal. Right? So when the authors, they hold the copyright, they will ensure that open access by signing a license to the publisher authorizing open access. So if you are doing PhD or you have finished PhD, if you are good at research, you will see that once your paper is published, it is accepted for publication. So before they go for publishing, they will ask you for transferring the rights, that is copyright agreement. We have to put a signature, either before we used to put the signature, scan and send it to the publisher, but now there is electronic signature, that is e-signature. That means you are transferring every right of yours to the publisher. That means publisher, he can do anything with your work. You don't have any rights to do anything from your work. Next, when it comes to the education, there are some copyrights. Say for example, for teaching purpose, if you want to use an article, then do you have the rights to use it? Some are allowed and some are not allowed. So the use of materials, it confined by the copyright, is important for the learning procedure. Usually they are called educational resources. So these educational resources, they exist in all formats and they are predictable as works in the copyright law. So if you are using these materials in an educational perspective for the classroom teaching or for some other purpose or face-to-face interaction, then it does not mean that you don't have to obtain or you don't have to obtain the license from the copyright holder. Definitely, if you want to use a material for the teaching purpose, there are some wherein you have to take the permission from the copyright holder, and there are some articles or there are some images or there are some materials or work which do not require any kind of obtaining the license. Now, what kind of material has to be used for teaching and what kind of material has not to be used for teaching? So based on that, you have to identify, okay, this message, okay, that message, it looks very beautiful, or that image, it looks very beautiful. Simply you cannot copy and put it in your presentation. You just take it for your presentation and you do the classroom teaching. That's fine. But if you want to put that recorded of the teaching in the website, that means you are making the website accessible worldwide, then the copyright holder, he may start questioning you. Yes, if you are not removing this, then I'll file a case against you. There are many instances. So immediately what you will do, you have to withdraw, you have to retract from your website. So that should not happen. So before you use anything, be very judicious in choosing what kind of material has to be used for teaching and what kind of material has not to be used for teaching or the education purposes. Next, there are two types of copyright issues in education. One is the public domain and the other one is licensing and copyright. First, we will talk about the public domain. So public, the name itself indicates it is accessible for everyone. Right? That means this public domain, the material is accessible by the public and it is done for the public. So this public domain, ಏನಾಗಬಹುದು ಕೆಲವು ಹಕ್ಕುಗಳು it may get expired, it may get forfeited and then given up, expressly relinquished sometimes, or it may be in improper format. If the works are inventive and not protected by the copyright, then this includes that works that have been in survival long enough. So that should not happen. And also this public domain, it includes works produced by the government. So if something is done by the government, it does not mean that there is no copyright. Definitely there is. What happens if something done by the government, then it is copyright is not required, but some of the government works there will be definitely copyrighted. So if a work is done in the public domain, then definitely you have to give the attributions. Attributions is giving the credits. So credits must be granted to the original creator, but if anybody uses that or even sells the work, then it will be a violation. You have to obtain the license. So everything is done legally. ಪ್ರತಿಯೊಂದನ್ನು ಕಾನೂನಾತ್ಮಕವಾಗಿಯೇ ನಾವು ಮಾಡಬೇಕಾಗಿರೋದು. Next, this public domain, it does not completely eliminate the original creator's rights. ಈ ಪಬ್ಲಿಕ್ ಅಂದ್ರೇನು, ನಾ ಏನ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಜನ ಕೊಟ್ಟೋಗ್ಬಿಡತ್ತೆ, ಪಬ್ಲಿಕ್ ಮಾಸ್ ಕೊಟ್ಟೋಗ್ಬಿಡತ್ತೆ, ನನಗೇನು ಕ್ರೆಡಿಟ್ ಇರಲ್ಲ, ಖಂಡಿತ ಹಂಗೇನಿರಲ್ಲ. ನಾನು ಅವಾಗ ಹೇಳಿದಾಗೆ some of the things are copyrighted, some of the things are not copyrighted. So based on the material, we should decide whether you have to go for copywriting or not. Coming to licensing and the copyright. So license ಅಂತಂದ್ರೆ ಏನು? It is a legal document. So when a work is created by someone, he owns the copyright. ನೀವಾಗ ಏನೋ ಒಂದು ಕಂಡಿದ್ದೀರಿ ಅದ್ಭುತವಾಗಿರೋದು, that means you will have that copyright. So that is ನಮ್ಮ ಹಕ್ಕು. ಕಾಪಿರೈಟ್ ತಗೊಳ್ಳೋದು ನಮ್ಮ ಆದ್ಯ ಕರ್ತವ್ಯ ಆಗಿರುತ್ತೆ ಇದು. ನೆಕ್ಸ್ಟ್, ಆ ಕ್ರಿಯೇಟರ್ ಇರ್ತಾರಲ್ಲ, he will decide who has to use this work and who should not use this work. And also for using a copyrighted work, he has to take a license from the authority. So obtaining the license from the authority for its use, for the permission to use, is very, very important, and everything should be in the written form, and also there should be a signature. Right? So if you are granting or receiving a license, the license ತಗೊಳ್ಳೋದಾದ್ರೂ ಸರಿ ಅಥವಾ ಕೊಡೋದಾದ್ರೂ ಸರಿ, it is always good idea to record the particulars of the license in writing. ಪ್ರತಿಯೊಂದು ಬರವಣಿಗೆಯಲ್ಲೇ ಇರಬೇಕು. ನೀವು ಸ್ವಲ್ಪ ದಿನ ಪೇಪರ್ ಕೆಳಗಡೆ ಓದಿರ್ಬೋದು, ಒಂದು ಸರ್ವೆ ಮಾಡಿದ್ದಾರೆ ಥ್ರೂಔಟ್ ದಿ ವರ್ಲ್ಡ್. ಸರ್ವೆ ಮಾಡಿದ್ದಾರೆ ಏನು ಅಂತಂದ್ರೆ, ನಮ್ಮ ಹಕ್ಕುಗಳನ್ನ ನಾವು ಬರ್ದಿಟ್ಬಿಡೋದು. ವಿಲ್ ಬರೆಯೋದು ಅಂತ ಕೇಳಿರ್ತೀರಾ ಅಲ್ವಾ? ಆ ವಿಲ್, ಎಸ್ಪೆಷಲಿ ಡ್ಯೂರಿಂಗ್ ದಿಸ್ ಕೊರೋನಾ ಪ್ಯಾಂಡಮಿಕ್, ಆ ವಿಲ್ ಬರ್ಸೋದು ತುಂಬಾನೇ ಪರ್ಸೆಂಟೇಜ್ ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂತೆ. ಯಾಕೆ? ನಮ್ಗೆ ಯಾವಾಗ ಕೊರೋನಾ ಬಂದು ನಮ್ಗೆ ಏನ್ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. ಹಂಗಾಗಿ ನಮ್ಮ ಆಸ್ತಿ ಬೇರೆ ಯಾರೋ ತಗೊಳ್ಳೋದ್ ಬದಲು ನಾವ್ ಯಾರು ಬರ್ದಿರ್ತೀವಿ ಅವ್ರಿಗೆ ಮಾತ್ರ ಹೋಗ್ಬೇಕು. ಸೊ ಯು ಆರ್ ಟ್ರಾನ್ಸ್ಫರಿಂಗ್ ಇಟ್ ಲೀಗಲಿ. ಅದಕ್ಕೇನೆ ವಿಲ್ ಮಾಡೋದು ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಂತ ಡ್ಯೂರಿಂಗ್ ದಿಸ್ ಕೊರೋನಾ ಪ್ಯಾಂಡಮಿಕ್. Next, it is also a good idea to record the license and have it signed both by the licensor and the licensee. ಯಾರು ಲೈಸೆನ್ಸ್ ಮಾಡಿಸ್ತಾ ಇದಾರೋ, ಯಾರು ಲೈಸೆನ್ಸ್ ತಗೋತಾ ಇದಾರೋ, ಇಬ್ಬರಿಂದನೂ ಸಿಗ್ನೇಚರ್, ಸಾಕ್ಷಿಗಳು ಅಂತ ಇರುತ್ತೆ ನೋಡಿ. ಅವ್ರಿಬ್ರು ಸಾಕ್ಷಿಗಳೇನೋ, ಅವ್ರಿಬ್ರು ಲೈಸೆನ್ಸರ್ ತಗೊಳ್ಳೋರು ಕೊಡೋರು ಇಬ್ಬರಿದ್ರೆ ಸಾಲಲ್ಲ, ಇನ್ನೊಬ್ರು ಯಾರಾದ್ರೂ ಸಾಕ್ಷಿ, ಇಬ್ರು 3 ಜನ ಸಾಕ್ಷಿಗಳು ಕೇಳ್ತಾರೆ. ಯಾಕೆ? ನಾಳೆ ಯಾರಾದ್ರೂ ಒಬ್ರು ಪ್ರಾಬ್ಲಮ್ ಮಾಡಿದ್ರೆ ಈ ಸಾಕ್ಷಿಗಳನ್ನ ಕರೆದುಬಿಟ್ಟು ಅವತ್ತು ನೀವು ಸಿಗ್ನೇಚರ್ ಹಾಕಿದ್ದೀರ ನೋಡಿ, ನೀವು ಕೂಡ ಇದಕ್ಕೆ ಜವಾಬ್ದಾರರು ಅನ್ನೋದನ್ನ ಹೇಳೋದಕ್ಕೆ ನಾವು ಸಾಕ್ಷಿಗಳನ್ನ ಹಾಕ್ತೀವಿ. ದಟ್ ಮೀನ್ಸ್ ರೈಟಿಂಗ್ ಈಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್, ಆಸ್ ವೆಲ್ ಆಸ್ ಸೈನಿಂಗ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಈಸ್ ಆಲ್ಸೋ ವೆರಿ, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. Next, we will come to the education and research. We can have the fair use in education and research. So fair use ಅಂತಂದ್ರೆ ಏನು? ನಾವು ಯಾವ್ದಾದ್ರು ಒಂದು ಉಪಯೋಗನ ಒಳ್ಳೆ ರೀತಿಯಲ್ಲಿ ಮಾಡ್ಕೋಬೇಕು. ಎಸ್ಪೆಷಲಿ ವೆನ್ ಇಟ್ ಕಮ್ಸ್ ಟು ದಿ ಎಜುಕೇಶನ್, Some of the illustrations are, you can go for a clipping. ಇವಾಗ ಯಾವುದೋ ಒಂದು ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಹೆಂಗ್ ವರ್ಕ್ ಆಗುತ್ತೆ ಅಂತ ತೋರಿಸ್ಬೇಕು. ನಮ್ಮ ಹತ್ರ ಕಾಲೇಜಲ್ಲಿ ಯೂನಿವರ್ಸಿಟಿ ಎಲ್ಲ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಇರೋದಿಲ್ಲ, ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಾ, ಯೂಟ್ಯೂಬ್ ಅಲ್ಲೋ ಯಾವ್ದೋ ಒಂದು ವೆಬ್ಸೈಟ್ ಅಲ್ಲೋ ತುಂಬಾ ಚೆನ್ನಾಗಿರತ್ತೆ ಅದ್ರದ್ದು ವಿಡಿಯೋ ವರ್ಕಿಂಗ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಅದನ್ನ ತೆಗೆದು ನಾನು ಕ್ಲಾಸ್ ಅಲ್ಲಿ ತೋರಿಸ್ತೀನಿ. ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಫೇರ್ ಯೂಸ್. ನೆಕ್ಸ್ಟ್, ಪೋಸ್ಟಿಂಗ್ ಮೆಟೀರಿಯಲ್. ನಾ ಯಾವ್ದೋ ಒಂದು ಮೆಟೀರಿಯಲ್, ಸೇ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಯಾವ್ದೋ ಒಂದು ರಿಯಾಕ್ಷನ್ ಮಾಡಿರ್ತೀನಿ ನನ್ನ ಕ್ಲಾಸ್ ಅಲ್ಲಿ, ಅಥವಾ ಯಾವ್ದೋ ಒಂದು ಗದ್ಯ ಪದ್ಯನ ಎಲ್ಲಿ ಚೆನ್ನಾಗಿ ತಗೊಂಡಿರ್ತೀನಿ ನಾನು, ಅದನ್ನ ನಾನು ಬರೀ ಟೀಚಿಂಗ್ ಮಾತ್ರ, ಎಜುಕೇಶನ್ ಪರ್ಪಸ್ ಮಾತ್ರ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ fair use. And also you are developing database of the copyrighted works for research. ಎಷ್ಟೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಗಳು ಕಾಪಿರೈಟ್ ಆಗಿದೆ, ಅದ್ರದ್ದೆಲ್ಲ ಒಂದು ಡೇಟಾ ಬೇಸ್ ಮಾಡ್ತಾ ಇದ್ಯಾ, ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡಿ ಒಂದು ಕಡೆ ಇಡ್ತಿದ್ಯಾ, ಒಂದು ಲಿಂಕ್ ಅಲ್ಲಿ ಅವೈಲಬಲ್ ಮಾಡಂಗ್ ಇಡ್ತಿದ್ಯಾ. ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಫಾರ್ ದಿ ರಿಸರ್ಚ್ ಪರ್ಪಸ್, ಎಜುಕೇಶನ್ ಪರ್ಪಸ್, ದೆನ್ ಇಟ್ ಈಸ್ ಎ ಫೇರ್ ಯೂಸ್. Next, if you have written an article and if it is published, you can share that material with classmates or with your colleagues. And also you can develop digital libraries. ಇವಾಗ ಯಾವುದೋ ಒಂದು ಕಾನ್ಸೆಪ್ಟ್ ಇರುತ್ತೆ, ಆ ಕಾನ್ಸೆಪ್ಟ್ ಬಗ್ಗೆ 100 ಜನ ಮಾಡಿರ್ತಾರೆ ವರ್ಕ್ ಅರೌಂಡ್ ದ ವರ್ಲ್ಡ್. ಆ 100 ಜನ ವರ್ಕ್ನ ಒಂದು ಕಡೆ ಇಡೋದು ಡಿಜಿಟಲ್ ಆರ್ಕೈವಿಂಗ್ ಅಂತ ಕರಿತೀವಿ. ಅದೆಲ್ಲ ಮಾಡೋದು ನಾವು ಅದನ್ನ ಫೇರ್ ಯೂಸ್ ಅಂತ ಕರಿತೀವಿ. ಸೊ ಪಂಚಮಂತ್ರಗಳಿರುತ್ತೆ ಫೇರ್ ಯೂಸ್ ಅಲ್ಲಿ. ನೆಕ್ಸ್ಟ್, ನಾ ಕಾಪಿರೈಟ್ ಅಂತ ಬಂದಾಗ ಅಕಾಡೆಮಿಕ್ ಪರ್ಪಸ್ಗೆ ದೇರ್ ಆರ್ ಬೋತ್ ಡಿಮೆರಿಟ್ಸ್ ಅಂಡ್ ಮೆರಿಟ್ಸ್. ಲಾಭಗಳು ಇರುತ್ತೆ, ಲಾಸ್ ಕೂಡ ಇರುತ್ತೆ. ಅದನ್ನ ನಾವು ಪ್ರಾಸ್ ಅಂಡ್ ಕಾನ್ಸ್ ಆಫ್ ಯೂಸಿಂಗ್ ಕಾಪಿರೈಟೆಡ್ ವರ್ಕ್ಸ್ ಫಾರ್ ಅಕಾಡೆಮಿಕ್ ಪರ್ಪಸ್ ಅಂತ ನಾವು ಕರಿತೀವಿ. ಯಾವುದು ಕೆಲವೊಂದು ಅಡ್ವಾಂಟೇಜಸ್, ಪ್ರಾಸ್ ಅಂದ್ರೆ ಅಡ್ವಾಂಟೇಜಸ್, ಕಾನ್ಸ್ ಅಂತಂದ್ರೆ ಡಿಸ್ಅಡ್ವಾಂಟೇಜಸ್, ಮೆರಿಟ್ಸ್ ಅಂಡ್ ಡಿಮೆರಿಟ್ಸ್. And this having copyright, it is very beneficial to teachers as well as students. ಖಂಡಿತ ನನಗೆ ಇವಾಗ ಯಾವುದೋ ಒಂದು ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ವರ್ಕಿಂಗ್ ಬೇಕು, ನನಗೆ ತೋರಿಸ್ಬೇಕು ನನ್ನ ಮಕ್ಕಳಿಗೆ. ನಾನು ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ನಾನೇ ನೋಡಿಲ್ಲ, ನಾನೇನ್ ತೋರಿಸ್ಲಿ ಮಕ್ಕಳಿಗೆ? ಸೊ ಇಫ್ ಇಟ್ ಇಸ್ ಅವೈಲಬಲ್ ಇನ್ ದ ವೆಬ್ಸೈಟ್, I can definitely take it from the website. I can show it to the students for the only for the education purpose. So that is definitely advantageous. And also this works, it contains some beneficial and important things. So which will tell about the unknown facts. ನನಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಇರೋದನ್ನ ನಾನು ಪಿಕ್ಚರ್ ಮುಖಾಂತರ ಅಥವಾ ವಿಡಿಯೋ ಮುಖಾಂತರ ನನ್ನ ಸ್ಟೂಡೆಂಟ್ಸ್ ಗೆ ನಾನು ತೋರಿಸ್ತಾ ಇದ್ರೆ, ಇಟ್ ವಿಲ್ ಡೆಫಿನೆಟ್ಲಿ ಎನ್ಹಾನ್ಸ್ ದಿ ನಾಲೆಜ್ ಆಫ್ ದಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಂಡ್ ಆಲ್ಸೋ ಇಟ್ ಹೆಲ್ಪ್ಸ್ ದ ಟೀಚರ್ಸ್ ಇನ್ ದ ಟೀಚಿಂಗ್. Then there are some disadvantages also of copywriting. Say for example, if the material is not used in a proper manner. ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಈಗೇನು ಈ ಪಿಕ್ಚರ್ ನಾನು ಗೂಗಲ್ ಇಂದ ತಗೊಂಡಿದ್ದೀನಿ, ಈ ಖಂಡಿತ ಈ ಪಿಕ್ಚರ್ ನಾನಂತೂ ಮಾಡಿದ್ದಲ್ಲ, ಯಾರೋ ಒಬ್ರು ಮಾಡಿದ್ರು, ತುಂಬಾ ಚೆನ್ನಾಗಿದೆ ಅಂತ ಅನ್ನಿಸ್ತು. ನೋಡಿ, ಹಿಂಗಿದ್ರೆ ಪ್ರಾಸ್, ಹಿಂಗಿದ್ರೆ ಕಾನ್ಸ್, ಮಕ್ಕಳಿಗೆ ಅಥವಾ ಯಾರಿಗಾದ್ರು ಅಟೆಂಡೀಸ್ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಗೆ ಚೆನ್ನಾಗಿ ಅರ್ಥ ಆಗುತ್ತೆ ಅಂತ ತಗೊಂಡಿದ್ದೀನಿ. ನಾನು ಇದನ್ನ ತಗೊಂಡು ಇದನ್ನ ನೋಡಿ, ಈ ಡಯಾಗ್ರಾಮ್ ನ, ಈ ಪಿಕ್ಚರ್ ನ ನಾನೇ ಮಾಡಿದ್ದು ಅಂತ ಅಂದ್ಬಿಟ್ರೆ, ಇಟ್ ಇಸ್ ಡೆಫಿನೆಟ್ಲಿ ಎ ಡಿಮೆರಿಟ್ ಆಫ್ ದಿ ಕಾಪಿರೈಟ್. ದಟ್ ಮೀನ್ಸ್ ಯಾರು ಕ್ರೆಡಿಟ್ ಹೋಗ್ಬೇಕೋ ಅವ್ರಿಗೆ ಕ್ರೆಡಿಟ್ ಹೋಗ್ಬೇಕು. ಅದು ಬಿಟ್ಟು ಯಾವುದೋ ಒಂದನ್ನ ತಗೊಂಡಿದ್ದೀನಿ ನಾನೇ ಮಾಡಿದ್ದು ಅಂತ ಕ್ಲೇಮ್ ಮಾಡೋದು, ಇಟ್ ಇಸ್ ಆಲ್ವೇಸ್ ಡಿಸ್ಅಡ್ವಾಂಟೇಜ್. ಎಸ್, there are some limitations ಏನೇನು ಅಂತ ಅಂದ್ರೇನು, ನ್ಯೂನ್ಯತೆಗಳು ಕಾಪಿರೈಟ್, ಎಸ್ಪೆಷಲಿ ಕಾಪಿರೈಟ್ ಮೆಟೀರಿಯಲ್ ಯೂಸ್ಡ್ ಇನ್ ದಿ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಯಾವ್ಯಾವ್ದು ಅಂತ ನಾವು ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್, ಈ ಕಾಪಿರೈಟ್ಸ್ ಅನ್ನೋದು ಇಟ್ ಇಸ್ ಬೆನಿಫಿಷಿಯಲ್ ಓನ್ಲಿ ಫಾರ್ ದಿ ಸ್ಟೂಡೆಂಟ್ಸ್, ಬೇರೆ ಇನ್ಯಾರಿಗೂ ಅದು ತುಂಬಾನೇ ಯೂಸ್ ಆಗಲ್ಲ. ನೆಕ್ಸ್ಟ್, ದೀಸ್ ಕಾಪಿರೈಟ್ ಮೆಟೀರಿಯಲ್ಸ್ ದೇ ಕ್ಯಾನ್ ಬಿ ಆಕ್ಸೆಸಿಬಲ್ ಫ್ರಮ್ ದಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಓನ್ಲಿ. ನೀವೇ ಕೆಲವು ಕಡೆ ನೋಡಿರ್ಬೋದು, ಎಸ್ಪೆಷಲಿ ದ ರಿಸರ್ಚರ್ಸ್. You will have seen that articles are accessible only from the institution and from the particular login ID itself. If you use, or if you go home, if you go to room and if you try to access that particular article, you cannot get the full PDF of that. Why it is that? Because it has been copyrighted with respect to the particular place. So within that bandwidth, that link will work. If you go home or if you go to your native or if you go somewhere else, that will not work. And also that has to be used from the institution internet itself. It is one of the limitations. A limitation ಅಲ್ಲಿ ಏನು, ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲಿ ಇಂಟರ್ನೆಟ್ ಇರಬೇಕು. ಪವರ್ ಹೊರಟೋಯ್ತು ಅಂತ ಅನ್ಕೊಳ್ಳಿ, ಪವರ್ ಹೋಯ್ತು ಅಂತ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಇಂಟರ್ನೆಟ್ ಕಟ್ ಆಗಿ ಹೋಗ್ಬಿಡುತ್ತೆ. Then I don't have access for any articles for that 1 hour or 2 hour for the whole day. I have to sit idle without doing any research. And also some other person also cannot use. ನಿಮಗೆ ಒಂದು ಲಾಗಿನ್ ಅಂತ ಕೊಟ್ಟಿರ್ತಾರೆ, ನಿನ್ನ ಲಾಗಿನ್ ಅಲ್ಲಿ ನೀನೇ ಹಾಕ್ಬೇಕು. ನಿನ್ನ ಲಾಗಿನ್ ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಬೇರೆಯವರು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಎಲ್ಲ ಮಾಡ್ತೀನಿ ಅಂದ್ರು, ಇಟ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್. ಸಿಂಗಲ್ ಲಾಗಿನ್ ಇಸ್ ದೇರ್ ಆಲ್ವೇಸ್. Right? Next, this use of material is always restricted to the campus itself and it is definitely a limitation. ಎಲ್ಲ ಕೆಲಸ ನಾವು ಕ್ಯಾಂಪಸ್ ಅಲ್ಲಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಎಲ್ಲ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ನಾಟ್ ಪಾಸಿಬಲ್. ಟೈಮ್ ಆಗೋಗಿರುತ್ತೆ, ಸಾಯಂಕಾಲ ಕತ್ಲೆ ಆಗೋಗಿರುತ್ತೆ, ನಾ ಮನೆಗೆ ಹೋಗ್ಬೇಕು, ಮನೆಗೆ ಹೋಗಿನೂ ಆ ವರ್ಕ್ ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕು, ನನ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಯಾಕೆ? ಕಾಪಿರೈಟ್ ಇಸ್ ಗಿವನ್ ಓನ್ಲಿ ಫಾರ್ ದಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಆಗಿ ನೋಡ್ಲಿ, ಇನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಇದ್ರೆ ಮಾತ್ರ ನಾನು ಮಾಡಕ್ ಆಗೋದು, ಹೊರಗಡೆ ಬಂದ್ರೆ ನಾನು ಮಾಡಕ್ ಆಗಲ್ಲ. ಸೊ ಅಗೇನ್ ಇಟ್ ಇಸ್ ಎ ಲಿಮಿಟೇಷನ್. Now, one of the examples for that limitation is the Manopatra. So, it is a site which gives the detailed information relating to law-based on the membership by the institution. ಈ ಮನೋಪಾತ್ರ ಅನ್ನೋದು ಒಂದು ವೆಬ್ಸೈಟ್ ಲಾಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು, ಕಾನೂನಿಗೆ. ಸೊ ದಿಸ್ ಇಸ್ ಆಕ್ಸೆಸಿಬಲ್ ಓನ್ಲಿ ಬೈ ದಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಇನ್ ದ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಬೈ ದ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಫಾರ್ ದ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಷ್ಟೇ. ಅದು ಬಿಟ್ಟು ಹೊರಗಡೆ ಅದನ್ನ ಆಕ್ಸೆಸ್ ಮಾಡಕ್ಕೆ ಖಂಡಿತವಾಗಿಯೂ ಸಾಧ್ಯನೇ ಇರಲ್ಲ. ಸೊ ದೀಸ್ ಆರ್ ಸಮ್ ಆಫ್ ದಿ ಲಿಮಿಟೇಷನ್ಸ್ ಆಫ್ ದಿ ಕಾಪಿರೈಟ್ ಮೆಟೀರಿಯಲ್ ವಿಚ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಯೂಸ್ಡ್ ಇನ್ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್. ನೆಕ್ಸ್ಟ್ ಇಸ್ ಕಾಪಿರೈಟ್ ಅಂಡ್ R4L e-journals. ಸೊ ಇತ್ತೀಚೆಗಷ್ಟೇ ಈ ಜರ್ನಲ್ ಅಂತ ಬರ್ತಿದೆ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಒಂದು 40-50 ವರ್ಷದ ಹಿಂದೆ ನಾವು ನೋಡಿದ್ರೆ ನಿಮ್ಗೆ ಬರೀ ಜರ್ನಲ್ ಎಲ್ಲ ಪ್ರಿಂಟ್ ಆಗಿ ಬರ್ತಿತ್ತು, ಪ್ರಿಂಟ್ ಪಬ್ಲಿಕೇಶನ್. ಇವಾಗ ಹೆಂಗೆ ನ್ಯೂಸ್ ಪೇಪರ್ ಅಂಡ್ ನ್ಯೂಸ್ ಚಾನೆಲ್. ನ್ಯೂಸ್ ಪೇಪರ್ ಅನ್ನೋದು ಪ್ರಿಂಟೆಡ್ ಎಡಿಷನ್, ನ್ಯೂಸ್ ಚಾನೆಲ್ ಅನ್ನೋದು ಈ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀಡಿಯಾ ಹೋಗುತ್ತೆ. ಅದೇ ತರ ಪಬ್ಲಿಕೇಶನ್ಸ್, ಜರ್ನಲ್ಸ್ ಅಷ್ಟೇ ಮುಂಚೆ ಎಲ್ಲ ಪ್ರಿಂಟ್ ಆಗ್ತಾ ಇದ್ವು, ಬಟ್ ಇವಾಗ ಎಲ್ಲಾನು ಈ ಜರ್ನಲ್ಸ್ ಅಂತ ಕರಿತೀವಿ ನಾವು, ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಜರ್ನಲ್ಸ್. Next, R4L ಅಂತಂದ್ರೆ Research for Life. So Research for Life, it is a foundation which gives access to the underdeveloped countries to make use of some scientific content. There are mainly 5 foundations of Research for Life. One is Kinari, that is Research for Health, and the second one is Agora, that is Research in Agriculture, OIR, that is Research in the Environment, RD, Research for Innovation, and the last one is Goali, it is the Research for Global Justice. So what does the Research for Life program is? It allows the users to use up to 50% of a journal issue, and you can distribute among your colleagues within the institution, and you can also use it for the educational purposes. And users, it cannot distribute outside the institution, you cannot change the content, you cannot load material, that means you cannot upload material for this. Whatever is there, you have to download and share among your colleagues within the institution. It should not go outside the institution, and also it is not for the public, and it is not for the use for profit. You cannot also use it for your own economy booster or for the profit purpose, right? The next important thing that you have to study is about the Creative Commons, which has got the symbol CC. CC ಅಂತ ಬರ್ಬಿಟ್ಟು ಸುತ್ತ 0 ಒಂದು O ಹಾಕಿದ್ರೆ ಅದನ್ನ ಕ್ರಿಯೇಟಿವ್ ಕಾಮನ್ಸ್ ಅಂತ ಕರಿತೀವಿ. ನಾವು ಇಷ್ಟೊತ್ತೂ ಕಾಪಿರೈಟ್ ಮೆಟೀರಿಯಲ್ಸ್ ಗೆಲ್ಲ ಲಿಮಿಟೇಷನ್ಸ್ ಓದಿದ್ವಿ, ಡಿಸ್ಅಡ್ವಾಂಟೇಜಸ್, ಡಿಮೆರಿಟ್ಸ್ ನೋಡಿದ್ವಿ. ಆ ಡಿಸ್ಅಡ್ವಾಂಟೇಜ್ ಎಲ್ಲಾನು ಹೊರಗಡೆ ಬರೋದಕ್ಕೆ ಕೆಲವು ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ತಂದ್ರು. ಆ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ಕ್ರಿಯೇಟಿವ್ ಕಾಮನ್ಸ್, ರೈಟ್? So what the basic facts the author should know is the copyright protection is automatic once the work is fixed in the tangible medium. ಏನು ಯಾವುದೋ ಒಂದು ವರ್ಕ್ ಮಾಡ್ತಿದೆ, ಅದನ್ನ ಪಬ್ಲಿಷ್ ಮಾಡ್ತಿದೆ ಅಂತಂದ್ರೆ it goes without saying that your work is copyrighted in some cases. Next, even if the article shares 5 authors or 10 authors or 15 authors, all the authors they will get equal copyrights. ನನಗೆ ಫಸ್ಟ್ ಆಥರ್ ಮಾತ್ರ ಜಾಸ್ತಿ ಅಥವಾ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಆಥರ್ ಮಾತ್ರ ಜಾಸ್ತಿ ಖಂಡಿತ ಇರಲ್ಲ. ಆ ಪಬ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ 10 ಜನ ಆಥರ್ಸ್ ಇದ್ರೆ ಆಲ್ ದ 10 ಆಥರ್ಸ್ ವಿಲ್ ಗೆಟ್ ದ ಈಕ್ವಲ್ ಕಾಪಿರೈಟ್ಸ್. And if you want to transfer the copyright, it can be done only through writing, nothing orally. ನೀವು ಸುಮ್ಮನೆ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಇಟ್ಬಿಡ್ತೀನಿ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಹಂಗೆ ಹಿಂಗೆ ಅಂದ್ರೆ ನಥಿಂಗ್ ಇಸ್ ಪಾಸಿಬಲ್. ಎವ್ರಿಥಿಂಗ್ ಶುಡ್ ಬಿ ಡಾಕ್ಯುಮೆಂಟೆಡ್ ಅಂಡ್ ಪ್ರಾಪರ್ಲಿ ಸೈನ್. And also, we should note that all the rights cannot be given away. For the author, or copyrights can be broken apart, right? So that is what is all about Creative Commons. Next is the author rights. So, what do you mean by a copyright? It is a bundle of rights. So these are exclusive rights which include you can reproduce the work in copies, you can distribute the copies of the work, you can publicly display or perform it, you can make derivatives, adaptations, translation. ಯಾವುದೋ ಒಂದು ನೀವು ಕನ್ನಡದಲ್ಲಿ ಬರ್ದಿರ್ತೀರಾ ಅಂತ ಅನ್ಕೊಳ್ಳಿ, ಕನ್ನಡದನ್ನ ಇಂಗ್ಲಿಷ್ಗೆ ತರ್ಜುಮೆ ಮಾಡ್ಬೋದು, ಹಿಂದಿಗೆ ಮಾಡ್ಬೋದು, ಮರಾಠಿಗೆ ಮಾಡ್ಬೋದು, ಉರ್ದುಗೆ ಮಾಡ್ಬೋದು, ಅದೆಲ್ಲನೂ ಮಾಡ್ಬೋದು. ಯಾವಾಗ ಇಫ್ ಯು ಓನ್ ದಿ ಕಾಪಿರೈಟ್. If you are giving all the rights to the publisher, you cannot do any of these things, right? That's why ಮುಂಚೆ ಹೆಂಗಿತ್ತು ಅಂತಂದ್ರೆ ಟ್ರೆಡಿಷನಲ್ ವೇ ಆಫ್ ಕಾಪಿರೈಟ್ ಅಗ್ರಿಮೆಂಟ್ ಹೆಂಗಿತ್ತು ಅಂತಂದ್ರೆ ಇಫ್ ಯು ಆರ್ ದ ಆಥರ್ ಯು ಆರ್ ಟ್ರಾನ್ಸ್ಫರಿಂಗ್ ಆಲ್ ದ ರೈಟ್ಸ್ ಟು ದಿ ಪಬ್ಲಿಷರ್. ನಿನ್ನ ಹಕ್ಕು ಏನೂ ಇಲ್ಲ ನಿನ್ನ ಆರ್ಟಿಕಲ್ ಮೇಲೆ. ನಿನ್ನ ಆರ್ಟಿಕಲ್ ಅಂತಂದ್ರೆ ನಿನ್ನ ಹೆಸರಿರಕ್ಕೆ ಅಷ್ಟೇ ಹೊತ್ತು ನೀ ಬೇರೆ ಏನು ಮಾಡಕ್ ಆಗಲ್ಲ. ಬಟ್ nowadays they have brought lot of addenda to that. ಅಂತಂದ್ರೆ ಏನು, some of the rights will be with the author, some of the rights will be with the publisher. We will see now that is what is the author options. So in the traditional way, as I told, what it is transferring all the rights to the publisher. So author will no longer has the control over the work. So one of the author options is that licensing, that is called as Creative Commons. What is this Creative Commons? It enables the copyright holder, whether the copyright holder can be either author or publisher, where he will have the rights to tell what has to be given to others, whether it is partial rights or complete rights. So definitely it is coming under Creative Commons. And some of the addendum is singular, addenda is plural. So some of the addenda that they are given was, the first one is SPARC is the scholarly publishing and academic resources coalition. You can have science common as one of the addenda, and you have got CIC is Committee on Institutional Cooperation. These are some of the addenda which have been added to the copyright agreement transfer, and these refer to the desired rights to the author. And also these addenda, it will allow to negotiate between the author and the publisher. So author ಸ್ವಲ್ಪ ವ್ಯಾಪಾರ ಚೌಕಾಸಿ ನೆಗೋಸಿಯೇಷನ್ ಚೌಕಾಸಿ ಮಾಡಬಹುದು. ಓಕೆ, ಪಬ್ಲಿಷರ್ ನೀವು ಇದೊಂದಷ್ಟು ಕಾಪಿರೈಟ್ಸ್ ಇಟ್ಕೊಳ್ಳಿ, ನಾನು ಇದೊಂದಷ್ಟು ಇಟ್ಕೋತೀನಿ, ಎಲ್ಲಾನು ನೀವೇ ತಗೊಂಡ್ಬಿಟ್ರೆ ನಾನು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಟ್ರಾನ್ಸ್ಫಾರ್ಮ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಒಂದು ಡೆರಿವೇಟಿವ್ ವರ್ಕ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ನಾನು. ಅದಕ್ಕೆ ಕೆಲವೊಂದು ರೈಟ್ಸ್ ನ, ಕೆಲವೊಂದು ಹಕ್ಕುಗಳನ್ನ ನನಗ್ ಕೊಡಿ ಆಸ್ ಎನ್ ಆಥರ್, ಕೆಲವೊಂದನ್ನ ನೀವ್ ಇಟ್ಕೊಳ್ಳಿ ಆಸ್ ಎ ಪಬ್ಲಿಷರ್ ಅಂತ ಅಡೆಂಡಾ ತಂದ್ರು. ಸೊ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಲರ್ನ್ ಮೋರ್ ಅಬೌಟ್ ದ ಕ್ರಿಯೇಟಿವ್ ಕಾಮನ್ಸ್, ಯು ಕ್ಯಾನ್ ಆಕ್ಸೆಸ್ these sites. You will get in-depth knowledge about this addenda. Next, if you are anticipating something for the future of your work, andre you know, if you have discovered something new, and if you think that that new work of yours, it will back some capital to you, it will bring some profit to you, then you should know what are those anticipations. So anticipate future uses of your work. So share your work with the colleagues, distribute at conferences. So you can posters, or you can do oral presentation at the conferences. You can self-publish your work. You can, if you have got your own personal website, definitely you can go and put it there. You can put it in your CV also. And also, not only the link, you can give a full text of the article or the work in your website. And also, if it is not open access, definitely you can submit that work to the open access repository. You can republish, you can adapt, you can translate your work, and you can use that work in the classroom. And also, if you are contenting it, if you are contributing to a work, or if you are developing some course content, you can use it for the course packing also. These are some of the anticipations that the author should know the uses of his work or her work in the future. Then what are the publisher requirements? So the publisher, they want the traditional contracts. So ಏನು traditional contracts ಏನಾಗಿರುತ್ತೆ? Reproduction. They can reproduce the work, they can distribute the work, they can derivatize the work, they can have the control on the editorial, they can have digital archiving. Say for example, if everything is in the print format, they can always go for the e-electronic, that is digital archiving. They can even change the format of the work or the article. So these are all the different requirements that a publisher will have. That is the traditional one. Next, you should know as an author where you should begin your work. Before you begin your work, that means before you publish your work, you should know what are the rights you should have, what are the rights you should possess, and you should identify a publisher who gives you maximum rights. ಇವಾಗ ನೀವು ಯಾವ್ದೋ ಎಕ್ಸ್ ಪಬ್ಲಿಷರ್ ಹೋಗ್ತೀರಾ, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಎಲ್ಲ ರೈಟ್ಸ್ ನಮ್ದೇ ಅಂತ ಕಿತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಬಟ್ ಯು ಶುಡ್ ಐಡೆಂಟಿಫೈ ಎ ಪಬ್ಲಿಷರ್ ಹೂ ಗಿವ್ಸ್ ಮ್ಯಾಕ್ಸಿಮಮ್ ರೈಟ್ಸ್ ಟು ದಿ ಆಥರ್. That's why you should read the publishing agreement. That's why I have given it in the caps. Before you publish, you should write what are all the agreement. It says everything. ನೀವು ಪಬ್ಲಿಷ್ ಮಾಡುವಾಗ ನೋಡಿರ್ಬೋದು, ಪಬ್ಲಿಷಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್ ಅಂತ ಇರುತ್ತೆ, ನಾವು ಸುಮ್ಮನೆ ಟಿಕ್ ಮಾರ್ಕ್ ಕೊಟ್ಟು ಬಿಡ್ತೀವಿ. I agree ಅಂತ ಕೊಟ್ಬಿಡ್ತೀವಿ, but you should not do that. It runs to several pages, I know that, but you as an author, you should know what is there in the publishing agreement, and if it is not satisfying, you can ask them to include the addendum. ತಿದ್ದುಪಡಿಗಳನ್ನ ನೀನು ತಗೊಂಡ್ ಬಾ ಅಂತ ನೀನು ಖಂಡಿತ ಪಬ್ಲಿಷರ್ಗೆ ಕೇಳಬಹುದು. And also you can opt for the open access. Some of the addenda, as I said, it can be accessed from these search engines. Now, there is a new model of licensing that is called Creative Commons, that CC with encircled by a mark, that is called CC Creative Commons, and it is a solution for the copyright problem. This copyright is automatic and there is no opt-in or opt-out format. So, publisher ಏನು ಹೇಳ್ತಾರೋ ಮುಗ್ದೋಯ್ತು, ನೀನು ಅದಕ್ಕೆ ಏನು ಅಡೆಂಡಮ್ ತಿದ್ದುಪಡಿನ ತರಂಗಿಲ್ಲ, ನೀನೇನು ಮಾತಾಡೋದು ಇಲ್ಲ. But this copyright having through Creative Commons, it will entail some advantages for the authors also. This copyright is restrictive, that means to say that right belongs only to the author, or it can be transferred or shared with others, and for mass distribution online it is possible. If it is yes, how it is possible? All these things can be learned in the Creative Commons. So Creative Commons, it is regarded as a new licensing model. It is one of the addenda for the traditional publishing agreement. So you know that licensing and the marks, that is the trademark, it is a contract and it is for a fixed period of time. We should know how to transfer the rights. We should know to whom you have to give the permission or get the permission to use the work. And also this Creative Commons, it is a set of licenses, that is, it is a type of contract. The contract will be for a particular period of time and with the standard terms and conditions apply ಅಂತ ಹೇಳಿರ್ತಾರೆ, ನೀವು ನೋಡಿರ್ಬೋದು. So it is nothing but a Creative Commons, and using this Creative Commons you will have the permission either to copy the work, share the work, modify the work, or you translate the work. And this mark is a standard symbol and that is always used for the recognized and trust. There are mainly 4 types of licenses. I'm not going to the details of this. One is attribution, non-commercial, no derivative works, and share alike. And there are 6 combinations of this. You can have only attribution or attribution with share alike, attribution with no derivatives, attribution and non-commercial. And you can have the combinations with attribution, non-commercial, and share alike. The last one is attribution, non-commercial, and no derivative. You can have the details of this if you are interested with this website. Then what is the benefit of this CC? CC means Creative Commons license work. It can be used in teaching, it can be used for creating work, and also it can be used for research. And also you know that you can have license of your own works. You can give licensing for your own works. That can be done using Creative Commons. More about this is given in this website. And there will be no registration process. It is completely free. And once you get the license, you display the mark and you give the link to the license text. And this is the end of my talk. And I have taken the material from various references. This is the bibliographic references. See, these are not my original content. Somebody has explained what is copyright, and if I want to use that copyright, I have to give a credit by referencing him. So whatever the material I have used, everything I have given credit to them. So these are the references. So thank you very much to you all for the nice and wonderful time, and also thank the organizers for giving me an opportunity to be with you during this webinar. Thank you all. Thank you very much. All the very best for your future. Over to the organizers.
Thank you, sir, for sharing your knowledge regarding the academic research, copyright issues, publishing, and giving us detailed information about the copyrights, listening, copyright in education, limitation to copyrights, and all the rights. Thank you so much, sir. Any questions, then you're free to ask. Participants are free to ask any questions.
Good afternoon, sir.
Good afternoon, madam.
Sir, wonderful presentation.
Thank you.
Sir, one simple question.
Yeah, your voice is breaking, madam. Sorry.
Hello?
Madam, please go ahead. Your voice is breaking.
Sir. One simple question, sir.
Yes.
If two persons were unknowingly discovered the same designs or any new invention, that time to whom we will give the first copyright or intellectual property rights?
The person who comes first, obviously. So that's why whatever you do, immediately you have to take the copyright. You cannot wait. Okay, could I have done? Let me go to the registering person or the registrar tomorrow. No. If you have found out something today, immediately you should go for the copyright. So then you claim the ownership. Never delay the works. Do it at the very second itself.
Okay, thank you, sir.
Shall I ask question? Shall I ask? So there is another question, sir.
Yes, madam.
Sir, like you said, now, like we can take the, like, can we take the copyright images or sentences or whatever it is from others? Like, we need to take the permission from them, sir.
For taking sentences.
Even like images also it might be, sir. Any images, whatever it is, from their content, if we are taking, we need to take permission or what, sir? From them.
See, that is what it all depends. If it is purely for the educational purposes, yes, you can take. But simply you cannot take the image. Along with the image, you should copy that website link and you should put it below the image. That means you are referencing, you are giving credit to the ownership.
Okay. Okay, sir. Thank you, sir.
Yes.
I think we will wind the session.
All right. Thank you very much.
Thank you, sir. Thank you very much. Now, I request our beloved Principal Professor P.G. Patil, sir, to present the presidential remarks. Over to you, sir.
Okay. Good afternoon. Today's resource person, Dr. Vidyasagar and Dr. Suhas. Wonderful session. I'm really enjoyed your novel thoughts which you have shared with us. Under this pandemic, you shared your novel thoughts, shared time with us. I am grateful to you, sir. Suhas, sir, explained both in two languages, mother tongue and English. It is a very nice information, sir. We know penny is penny. ಅನ್ನುವ ತಲೆಯಲ್ಲಿದ್ದು ವಿಚಾರದಲ್ಲಿದ್ದೀವಿ. ಇವತ್ತು ಇಂಟೆಲೆಕ್ಚುವಲ್, the work which is done by the human brain, you can earn lot of things. That is called intellectual property right. You know, in this universe, the God have no Xerox machine. ಇವತ್ತು ಜಗತ್ತಿನಲ್ಲಿ ದೇವರು ಎರಡು ಟೈಪ್ ಇನ್ನೂವರೆಗೆ ಅವನಿಗೆ ನಿರ್ಮಾಣ ಮಾಡೋಕ್ಕಾಗಿಲ್ಲ. ಪ್ರತಿಯೊಬ್ಬನು ಯುನಿಕ್ನೆಸ್ ಇರುತ್ತೆ. ಯಾವುದೇ ಕೆಲಸವನ್ನ ಅದು ನನ್ನ ಕೆಲಸ ಅಂತ ಹೇಳೋ ನಾವು ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ಸ್, ಎಸ್ಪೆಷಲಿ ಇನ್ ರಿಸರ್ಚ್ ಫೀಲ್ಡ್ ಅಲ್ಲಿ, ಪೇಟೆಂಟ್ದಲ್ಲಿ ನಾವೆಲ್ಲ ಯಾರ್ದೋ ಕಾಪಿ ಕ್ಯಾಟ್ ಮಾಡಿಬಿಟ್ಟು ಅದು ನಂದು ಅಂತ ಹೇಳಿ ಕೋರ್ಟ್ ಕಚೇರಿಯಲ್ಲಿ ಬಡಿದಾಡ್ತಿರುವ ಪ್ರಸಂಗಗಳನ್ನ ನಾವು ಇವತ್ತು ನೋಡ್ತಾ ಇದ್ದೀವಿ. ವಿಶೇಷವಾಗಿ ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ನಾವು ನೋಡ್ತಾ ಇದ್ದೀವಿ. ಇದು ಆಗಬಾರ್ದು. ಯಾವ ಕಾನೂನು ನಮ್ಮನ್ನ ಗಟ್ಟಿಗೊಳಿಸುತ್ತದೆ ಬಗ್ಗೆ ಸಹಿಷ್ಣುವಾಗಿ ಡಾಕ್ಟರ್ ಸುಹಾಸ್ ಸರ್ ನಮಗೆಲ್ಲ ಹಂಚಿಕೊಂಡಿದ್ದಾರೆ. ನಿಜವಾಗಿ ವಿ ಆರ್ ಗ್ರೇಟ್ಫುಲ್ ಟು ಯು ಸರ್. ಬಟ್ ಐ ಥಿಂಕ್ ಸರ್ ದಿಸ್ ಐಡಿಯಾ ಶುಡ್ ಬಿ ಫ್ರಮ್ ಪ್ರೈಮರಿ ಸ್ಕೂಲ್. ಅಂದರೆ ನನಗನ್ನಿಸುತ್ತೆ ನಾವೆಲ್ಲ MSc ಮಾಡಿ ಕಾಲೇಜ್ ಪ್ರೊಫೆಸರ್ ಆಗಿದ ನಂತರ ರಿಸರ್ಚು ಮತ್ತು IPR ಬಗ್ಗೆ ಮಾತಾಡೋದಕ್ಕಿಂತ ಆ ಪ್ರೈಮರಿ ಹೈಸ್ಕೂಲ್ ಸೆಕ್ಷನ್ದಲ್ಲಿ ಈ ವಿಚಾರಗಳನ್ನು, ಇಂಟೆಲೆಕ್ಚುವಲ್ ಪ್ರಾಪರ್ಟಿ, ಆ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ನಮಗೆಲ್ಲ ಗುರುತು. ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಬಗ್ಗೆ ಹೆಚ್ಚು ಫೋಕಸ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಇಂಟೆಲೆಕ್ಚುವಲ್ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ನಾವು ವಿಚಾರ ಮಾಡ್ತಲ್ಲ. ಆ ವಿಚಾರವನ್ನು ಪ್ರೈಮರಿ ಹೈಸ್ಕೂಲ್ ಸೆಕ್ಷನ್ದಲ್ಲಿ ಆ ವಿಚಾರಗಳನ್ನ ತುಂಬಿದರೆ ಬಹುಶಃ ಬಹಳಷ್ಟು ನಾವು ಹೆಚ್ಚಿಗೆ ಅವೇರ್ನೆಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿದಂತಾಗತ್ತೆ. ಇವತ್ತು ನಮ್ಮ ಹಳ್ಳಿಗಳಲ್ಲಿ ರೂರಲ್ ಏರಿಯಾಸ್ ಸೋ ಮೆನಿ ನ್ಯೂ ಥಿಂಗ್ಸ್ ಆರ್ ದೇರ್. ದ ಕಾರ್ಪೆಂಟರಿ ವರ್ಕ್, ಮೇ ಬಿ ಕಾರ್ಪೆಂಟರ್ or any work, it is a very new thing, but unfortunately that they don't have get a patent. As you know, sir, just a straw, a flexible straw, straight straw, yes, they got a patent and they earn a lot of money from that. But unfortunately, India, in literary work or any heritage work, a lot of patent is eligible, but unfortunately they have not focused. I think, sir, a wonderful session, sir, especially Suhas sir and Vidya Sagar sir, both young assistant professor. I get surprised. You are too young. I am very eager to invite our college, sir. If you have time, please visit our college and inspire our young faculty members. I really am grateful to you, sir, because we are inviting research persons, almost aged resource persons, but you are too young and your language, your mastery over the subject really inspires us, not only students, the young faculty also. For your kind information, our college, near about 24 young, very young, energetic assistant professors are there. Please come to our college, inspire our college, our faculty members. So, what is patent? What can be patented? What cannot be patented? A really wonderful session, sir. I am really enjoyed your session in spite of my busy work. I am thankful to our chemistry department. So I invite you, sir, when offline starts, please welcome to our KLE college. These words I conclude my presidential remark. Thank you, Vanaya.
Thank you, sir, for your rich words. Gratitude is the fairest blossom that springs from heart. Now it's time to express our gratitude. I request Professor V.S. Khanapur sir to propose vote of thanks.
Okay. Good afternoon, everyone. Honorable dignitaries, distinguished guests, respected principal, IQAC coordinator of our college and HOD Department of Chemistry, and here participating on behalf of KLE GT College Gadag, its entire fraternity and the organizing committee, I feel immense pleasure to take this opportunity to propose vote of thanks. Firstly, to our eminent speaker, Dr. Vidyasagar CC, Assistant Professor, Department of Chemistry, Rani Chennamma University, who spared the time from his busy schedule to grace this state-level virtual seminar with his extremely relevant address on general aspects of IPR and an overview of patent system in India. He rightly talked about values. Intellectual property rights are the right given to persons over the creations of their minds. They usually give the creator an exclusive right over the use of his and her creation for the certain period of time. It should be also be noted that the exclusive rights given are generally subject to a number of limitations, expectations aimed at the fine tuning the balance that has to be found between the legitimate interest of right holders and of users. For his thoughts provoking insight and wisdom will all of us on the role of the IPR and overview of patent system in India. On behalf of our KLE GT College and behalf of our chemistry department, thank you, sir. My heartful thank goes to our one more eminent speaker, Dr. Suhas R., Assistant Professor, Department of Chemistry, JSS College, Arts, Commerce and Science, Mysore, who spared the time from his busy schedule to grace this state-level virtual seminar with his extremely relevant address on academic research and copyrights issue. He rightly talked about the values, the copyrighted material in the realms of the academic and research includes the articles in academic journals, contributions to an anthology, and collections, monographs and newspaper articles, presentations and scientific and conference, posters, photos. Work must be constitute a personal intellectual creation at it must also reach a certain threshold of originality, demonstrations and individual characters and degree of creativity in its form and content. For his thought provoking insight on the role of academic research and copyright issues. Thank you, sir, on behalf of KLE College and behalf of Chemistry Department. Thank you, sir. I take this opportunity to special express my deep regards and gratitude, Sri President of this state level virtual seminar, Sri PG Patil, Principal of our KLE College, for always encouraging us and for his unflattering support to organize such an event. Thank you, sir. I also extend my special thank our IQAC coordinator, Dr. GK Ramesh, sir. Thank you, sir. I would like to thank our HOD and organizing secretary, Dr. MB Patikar, sir. Thank you, sir, for his support, encouraging and guidance. Thank you, sir. My deep sense of appreciation and thank all the faculties and participants who choose to be live with us and attended the state level virtual seminar with great enthusiasm and made it successful event. My sincere gratitude also goes to the organizing committee for taking topics that really matter for upcoming researchers and student researchers. Last but not the least, for all the technicals supporters and for helping us webcast webinars through our internal aid. Once again, thank you one and all.
Thank you, sir. I request all the participants to fill the feedback forms to receive the certificates. Feedback link will be soon posted in the chat box. So please do fill the feedback and then leave the meeting. Thank you. ಸೊ ನಿಮ್ದು ಇದರಲ್ಲಿದೆ
ಇಲ್ರಿ ಇದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಐತೆ ನೀವು ಮ್ಯಾಕ್ಸಿಮೈಸ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀರಾ
ಸೊ ಡಬಲ್ ಟ್ಯಾಪ್ ಮಾಡಿದ್ರೆ
ಅನೌನ್ಸ್ ಮಾಡಿ ಚಾಟ್ ಬಾಕ್ಸ್ ಹಾಕಿದ್ದೀನಿ
feedback link is being posted in the chat box. Please do fill the feedback to get the certificates. ಕೀರ್ತಿ ಅದು ಲಿಂಕ್ ಕಾಪಿ ಮಾಡಿ ವಾಟ್ಸಪ್ಪಿಗೆ ಹಾಕಿ ನಂಗೆ ನಾನು ಮೀಟಿಂಗ್ ಲೆಫ್ಟ್ ಆಗಿದ್ದೆ ಹಾಕಿ
JDC chemistry
ಕೀರ್ತಿ ಕಳ್ಸೆ. ನಾವು ಅವ್ರ
ಕನ್ನಡದೊಂದು ರಿಪೋರ್ಟ್ ಮಾಡಕ್ಕೆ ಕನ್ನಡದಲ್ಲಿ ಅದು ಇದು ಎರಡು ಸೇರಿಸಿ ನಿನ್ನೆದಾ ಓಕೆ ಮೊನ್ನೆ ವೆಬಿನಾರ್ ಓಕೆ
ಸ್ಟೇಟ್ ಲೆವೆಲ್
ಹಾಂ 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 ಹಂಗಲ್ಲ ಫೋಟೋಣ ರಿಪೋರ್ಟ್ ನಿನ್ನ ಹತ್ರ ಇತ್ತಲ್ಲ
similar feedback link BIRTU.
ಮೇಡಮ್ ಇದು ಲಿಂಕ್ ಅಷ್ಟೇ ಬರುತ್ತೆ
ಹಾಂ ಸರ್ ಲಿಂಕ್
ಮೇಲ್ಗಡೆ ಏನು
ಇಲ್ಲ ಸರ್ ಇಷ್ಟ
ನಾನು ನಿಮಗೆ ವಾಟ್ಸಪ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಒಂದು ವೆಬಿನಾರ್ ಒಂದು ಫೋಟೋ
ವರ್ಚುವಲ್ ಕರೆಕ್ಟ್ ಐತಿ.
ಅದು ಹಾಕಿ ಬರ್ದು ಕಳಿಸಿ
ಬರಿಸಿದ ಕಳಿಸಿ.
ವೆಬಿನಾರ್ ಯಾವ್ದು ಫೋಟೋ ಸರ್ ವೆಬಿನಾರ್
is friends and copyright. ಯಾರ್ದ ಫೋನ್ ಬರತ್ತೆ? ಹಲೋ ಯಾಕೆ ಏನು ಅರ್ಜೆಂಟ್ ಇತ್ತು? ಇಲ್ಲ ಸ್ವಲ್ಪ ಕೆಲಸ ಇತ್ತು ಬಿಡ್ತೀನಿ ಇಲ್ಲಿ ಅಪ್ಪಾಜಿ ಬೇಡ ಅಂತ ಹಚ್ಚಿದ್ನ ಫೋನ್ ಇಲ್ಲಿ ಬೇಡ ನಡೀತೈತಂತ ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹಂಗ ಊರಿ ಬಸ್ ಇದೆ ಅಂತ ಅಷ್ಟು ತೊಗೊಂಬರ್ತೀನಿ ಸೋಮವಾರ ಇಲ್ಲ ಜಿಮ್ 5 ದಿನ ಅಷ್ಟೇ ಇರ್ತದೆ ವಾರದಲ್ಲಿ ಸೋಮವಾರ ಇರಲ್ಲ ಇಲ್ಲ 15 ಸೋಮವಾರ ಜಿಮ್ ಇತ್ತನಂತಾದ್ರೆ ಶುಡ್ ಕಂಪ್ಲೀಟ್ ಅಸೈನ್ಮೆಂಟ್ ನೋಡಿ ಶ್ವೇತಾ ಬಾ ಬಂದು ಮಾಡಿದ್ವಿ ಫೋಟೋ ತೆಗ್ದೇ ಇಲ್ಲ ಇಲ್ಲ ಆಮೇಲೆ ತೆಗ್ದಿದ್ದು ಹಾಕಿಲ್ಲ ನಾನು ನೋಡಿದ್ದೆ
ಇದನ್ನ ಯಾರು ಆನ್ ಮಾಡಿಲ್ಲ ಮ್ಯೂಟ್ ಮಾಡಿ
ಏನು ಸರ್ ಯಾವ್ದು ಹಾಂ ಎಲ್ಲಿಗೆ ಚಟಿ ಪರಿವಾರಕ್ಕ ಹಾಕಿದ್ದೀರಲ್ಲ ಓಕೆ ಸರ್ ಹಾಂ ಹಾಂ ಕರ್ಕೊಬಿಡ್ರಿ ಅವರು ಕರ್ಕೊಬಿಡ್ತಾರಲ್ಲ
ಅಲ್ಲ ಇದು ಒಂದು PDF ಕ್ಲಾಸ್ ಪ್ರಿಂಟ್ ತರಿಸ್ಬೇಕಾಗಿತ್ತು ಒಂದು PDF ಕಳಿಸ್ತೀನಿ ಅದನ್ನ ಪ್ರಿಂಟ್ ತಗೋಬೇಕಾಯ್ತು ಅಲ್ಲೆಲ್ಲ ನೋಡ ಎಲ್ಲೇ ಅಲ್ಲಿನ ಇರ್ತಾವ ನೋಡ ಎಷ್ಟು ಒಂದು ಪ್ರಿಂಟಿಗೆ ಎಷ್ಟು ಕೇಳು ನಾವು ಫೋನ್ ಹಚ್ಬೇಡಿ
ಮೂರು ಮಂದಿ ಸರ್ವಿಸ್
ಅಂದ್ರೆ ಅದು ಮುಗಿದೋಗ್ಬಿಟ್ಟಾಯ್ತಲ್ಲ ಏನು ಪ್ರಾಬ್ಲಮ್ ಲಾಕ್ಡೌನ್ನಾಗ ಏನಾಗಿತ್ತು ಬಂದ್ಮೇಲೆ ಏನು ಯಾರು ಪ್ರೆಸ್ ಮಾಡಿದ್ರೆ
ಒಂದು ಸ್ವಲ್ಪ ಬಿದ್ದು ಬಂದು
ಇದನ್ನ ಟೈಟ್ ಮಾಡ್ಬೇಕು ಇದನ್ನ ಇದು ಮಾಡಲಿಲ್ಲ ಸ್ವಲ್ಪ ಟಚ್ ಬಿದ್ದೈತೆ ಅಷ್ಟೇ ಅಲ್ಲ ಏನೋ ಹೋಲ್ಡ್ ಮಾಡೋದು ಇದನ್ನ ತರ್ಬಿಟ್ಟು ಹೆವಿ ಕೆಲವು ಅನ್ಸಿದ್ ಮಾಡಬೇಕಾಗಿತ್ತು ಅಷ್ಟೇ
ಕುಂಕುಮ
ಲಾಕ್ಡೌನ್ನಾಗೆ ಬಿಫೋರ್ ಕಾರ್ತಿಕ್ ಸರ್ವಿಸ್ ಕಂಡಿದ್ರು ಒಂದು ವಿಡಿಯೋ ಮಾಡ್ತೀನಿ ಅಂದ್ಬಿಟ್ಟು
ಮತ್ತೊಂದು ಸ್ಟ್ಯಾಂಡ್
ನಾನು ಕೇಳಿದೆ ಸುಮಾರು ಸತೀಶ್
ಎಲ್ಲ
ಜ್ಞಾಪಕ ಅಂತ
ಇನ್ನೂ ಐಟಮ್ ಭಾಳ ಇನ್ನೊಂದು ಅಲ್ಲಿ ಇಡ್ತೀನಿ ನೋಡು 6 ಲೀಟ್ರ್.
ಏನಂದ್ರೆ ಒಂದು ಅರ್ಧ ತಾಸು ಲೇಟ್ ಆಗಿರ್ತದೆ.
ಸರ್ ಹೇಳಿ. ಹಾಂ ಸರಿ ಸರಿ ಸರ್ ಬಂದೆ. ಓಕೆ 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 ಬನ್ನಿ. ಓಕೆ
ಮತ್ತು ಮತ್ತು
ಭಾಳ ಅದ ರೀ ಅವ್ರೊಬ್ರು ಯಾರು
ಇನ್ನೊಂದು ಹೇಳಕ್ಕೆ ಹೇಳಿ ಅವ್ರ ಮಗ ರೆಡಿ ಆಗ್ಯಾನ ಅದನ್ನ ಅವ್ರಿಗೆ ಇದು ಎಷ್ಟು ಕಷ್ಟ ಬರ್ತದೆ ನನಗೆ ನಿಮ್ದು ನಾವೆಲ್ಲ ಸತೀಶ್ಗೆ ತಗೊಂಡು ಬರೋಕ್ಕೆ ಅರ್ಧ
ಗಾಡಿ ಗಾಡಿ
ಇನ್ನೂ ಭಾಳ ಐತೆ ಹಲೋ ಸರ್ ಇಲ್ಲಿ ಆಫೀಸ್ದಾಗೆ ಇದೆ ಇವಾಗ 10 ನಿಮಿಷದಲ್ಲಿ ಬನ್ನಿ ಸರ್ ಹಾ ಅದೇ ಸರ್ ನಿನ್ನೆ ನಾ ಬಂದಿದ್ದೆ ಸರ್ ಬಟ್ ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಸರ್ ಎಲ್ಲ ನಾವು ವಾಪಸ್ ಸರ್ ಮೊದಲೆಲ್ಲ ಬೈಕ್ ಹಲೋ ಸರ್. ಇನ್ನೂ ಜಾಸ್ತಿ ಐತೆ. ಹೌದು, ಏನು ಬೈಕ್ ಹೋಗ್ಬರ್ರಿ ಅಂದ್ರೆ ತಗೊಂಡು ಬರ್ತಿದ್ರಿ. ಸಪೋಸ್ ಜಾಸ್ತಿ ಇದ್ರೆ ತಗೊಂಡು ಬರ್ತಿದ್ರೆ, ಇಲ್ಲಾಂದ್ರೆ ಹಂಗೆ ಒಂದ್ಸತಿ ತಗೊಂಡು ಬರ್ರಿ ಬೇಡ. ಬರ್ರಿ ಆಲ್ಮೋಸ್ಟ್ ಈಗ ಮುಗಿಸ್ಯಾರ. ಮೇನ್
ಹಲೋ ಈಗ ಮುಗಿದ ಕೆಲಸ ಹಾಂ ಹಾಂ ಮಾಣಿಕ್ಯ ಅಮ್ಮ ಎರಡು ರೂಪಾಯಿ ಹಾಕ್ತಾರೆ ಕೆಲಸ ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಸರ್ ಇಲ್ಲ ಮುಂದೆ ಮುಂದೆ ಹಾಕ್ತಾರೆ ಅಲ್ಲೇ ದೃಷ್ಟಿ ಇದು ಮನೆಗೆ ಮುಂದೆ ಸ್ವಲ್ಪ ಮುಂದೆ ಅಲ್ಲೇ ಇರ್ತದೆ ಅಷ್ಟೇ ಹೇಳ ಹೇಳಿ ಹಾಕಿ ಸರ್ ಇದು ಒಂದೇ ಪ್ರಿಂಟ್ ಹಾಕಿ ಸರ್ ಫಸ್ಟ್ ಪೇಜ್ ಐತಲ್ಲ ಅದನ್ನ ಕಲರ್ ಹಾಕಿ ಸರ್ ಫಸ್ಟ್ ಪೇಜ್ ನಾನು ಫೋಟೋ ಇದ್ದು ಐತಲ್ಲ ಅದು ಕಲರ್ ಹಾಕಿ ಸರ್ ಹಾಂ ಫಸ್ಟ್ ಪೇಜ್ ಏನು ನನ್ನ ಫೋಟೋ ಇದ್ದು ಐತಲ್ಲ ಅದ ನನ್ನ ಫೋಟೋ ಇದ್ದು ಏನೈತಲ್ಲ ಫಸ್ಟ್ ಪೇಜ್ ಐತನ ಇಲ್ಲ ಅದು ಒಂದೇ ಕಲರು ಉಳಿದಿದ್ದಲ್ಲ ಇದು ಏನು ಬೇರೆ ಹಾಕ್ಸ ಆಮೇಲೆ ಹಾಂ ಏನೇ ಎರಡ ಇರ್ಬೋದಲ್ಲ ಅದು ಒಂದು ಕಲರ್ ಹಾಕ್ಸ ಒಂದು ನಾರ್ಮಲ್ ಹಾಕ್ಸ ಒಟ್ಟು ಅದು ಫೋಟೋ ಇದ್ದಿದ್ದು ಕಲರ್ ಉಳಿದಿದ್ದು ನಾರ್ಮಲ್ ಅಂಥವು ಒಂದು ತೆಗೆದ್ರೆ ಒಂದು ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಬೇಕು ಜೆರಾಕ್ಸ್ ಮಾಡಿಸಿ ನೋಡಿಸ್ತೇನೆ ಕೊಡಿ ಚಂದ ಐತೆ.
ಇಲ್ಲಿ ಅಂದ್ರೆ ಸರ್ವಿಸ್ ನೋಡ್ರಿ ಹಿಂಗ ರೌಂಡ್
ಹೌದೌದು. ಹಾಂ ಹೌದು. ಹಾಂ ಹೌದು. ಹೌದು. ಅವ್ರು ಇದನ್ನು ಕಳಿಸಿದ್ರೆ ಸಾಫ್ಟ್ ಕಾಪಿ ವಾಟ್ಸಪ್ನಲ್ಲಿ ಕಳಿಸಿದ್ರೆ ಬರ್ತದೆ. ಯಾರು ಪೇಜ್ ಬೇಕು ಅದನ್ನ ಪ್ರಿಂಟ್ ಕೊಡ್ತೀವಿ. ಹಾಂ ಅಷ್ಟೇ, ಯಾರು ಪೇಜ್ ಹಾಕಿದ್ರೆ ಅದನ್ನ ಬೇಕಾದ್ರೆ ಕಳಿಸ್ತೇನೆ, ಪ್ರಿಂಟ್ ತೆಗಿಸ್ಕೊಟ್ಬಿಡ್ತೀನಿ. ಬರ್ತೇನ್ರಿ. ಬಿಟ್ಟೋಗ್ಬಿಡುತ್ತೆ, ಇನ್ನೂ 15 ನಿಮಿಷ ಹೌದು.